The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near, and they will be heard. God save the United States and this honorable court.
Please be seated. Good morning, everyone. We are heading into the last day of our term. We have a big day in front of us, and Judge McHugh is participating from Salt Lake City by Zoom due to things beyond her control, our control, but we are ready to proceed. We'll begin with the tri-state case, and this has been a work in progress. 5 petitions for review that we then sorted into 2 argument slots of our 6 cases, and now it is distilled further, consolidated into 1 argument, which makes sense. We appreciate the council's help in getting it in a way that we can resolve it the easiest and hear the arguments the best. So, my understanding is that the way that this will proceed is Tri-State will lead off and has 25 minutes allotted, of which it wants to try to reserve 3 minutes. Sometimes that works, sometimes it doesn't. Then 5 minutes for Intervenor-Petitioner Basin Electric, 25 minutes for FERC, and 5 minutes for Intervenor-Respondent United Power. If I got it right, anybody raise your hand if I'm out to lunch, and you raised your hand, but you were taking your purse off, I think, so I won't count that one. That being the case, I think we are ready to proceed, and so counsel, when you're ready, we're ready for you.
Thank you, Your Honor. Misha Tsaitlin for the petitioner. I am going to try to reserve 5 minutes for rebuttal, but we'll see how that goes.
Understood.
I represent Tri-State, a non-for-profit generation and transmission cooperative, and I'm here speaking for our cooperative members who serve customers in Western states. Our cooperative members each contractually agreed to take all the requirements of their power from Tri-State until 2050. These long-term commitments are the backbone of our cooperative, as this court explained in this Shoshone case. In setting a contractual termination payment methodology, FERC entirely failed to set a just and reasonable rate under the Federal Power Act for 3 fundamental reasons that I will discuss today. First, FERC's methodology gives no weight and pays no account to the fact that these are long-term contractual commitments. That is a fundamental violation of the Federal Power Act and the APA. Clearly, the fact that these are long-term commitments is an important consideration, and the fact that FERC's methodology gives us no weight, gives the exact same number, regardless of whether the WESC has 3 years left on it or 40, is just a clear error of law requiring vacature on that basis alone. Second, the methodology that FERC adopted, which is a single-minded focus on a snapshot of our balance sheet, current balance sheet, unquestionably shifts costs to remaining members. Now, while there's some disagreement around the margins here, most of the points in this aspect of the case are undisputed. They do not dispute that a methodology is not just and reasonable if it shifts costs. Further, they do not dispute that 2/3 of our costs are not reflected on our debt, on our balance sheet. So they do not account for 2/3 of our cost. Their only answer for ignoring 2/3 of our cost is that we'll be able to right size away, which is operationally change, to get rid of some, but not all of those costs. Now, how much some, but not all, we can debate. But since it's undisputed that at least some costs can't be right-sized away, and it's further undisputed that a just and reasonable methodology must not shift costs, that is a clear error that requires vacature on that basis alone.
When you're talking about this 2/3 of costs, what do you mean by costs? Are you talking about debt?
No. So 1/3 is debt. That's the part that they account for, although with regard to transmission debt, they kind of messed that up too by things that we can discuss later. But for the 2/3, this is environmental mediation, labor costs, safety and training, systems operations, maintenance, compliance. They do not account for it at all in their calculation. Again, their only answer is this right-sizing point. But they don't, in their orders or in their brief, say that we can right-size away all the costs. Obviously, some can be right-sized, some can't. And since it is undisputed, as I read the orders on review in their brief, that some of the costs, the 2/3, can't be right-sized away, that's a cost shift that they don't account for. They admit that a just and reasonable methodology cannot shift costs, and that's reason alone to set aside the orders on review. And the third point is that they, by adopting this balance sheet approach, they did something with us and with our contracts that they've never done with any other cooperative or any other contract that they can point to. So adopting a methodology different for one set of contracts and one cooperative than you do for anyone else, that violates the APA unless you can give a good reason. And the only two reasons they give for this methodology that they're adopting in their brief and in the orders are just red herrings. They say, well, there's an issue with patronage capital. Patronage capital needs to be refunded under any approach. So that's a red herring as to why you'd want the balance sheet approach versus loss revenue approach or any other approach. That doesn't justify doing something different as to us. And their other point is that the departed member could still take some of the transmission services. That doesn't justify adopting the balance sheet approach. We accounted for that in our approach. It could be accounted for in a different approach. And in fact, the way they did the transmission with the crediting is just a complete mess, as we talk about, in both sets of appeals.
How does the open access transmission, how does that relate to the costs? In other words, if the departing members do indeed avail themselves of that, does that weaken or undermine your argument about the 2/3 cost?
No. So the open access aspect, as it relates to the credit as well, that has to do with the portion that they're paying for our debt to build the transmission wires and the substations and things of that sort. So that is not accounted for. That's not the 2/3 that we're saying is unaccounted for. We do have a very significant problem with how they've changed the transmission credit. So even with regard to that 1/3, it's not even close to 1/3 with the way they've structured the credit, but that's downstream of if the court approves their overall methodology that I'm happy to talk about. But the 2/3 is not that. That's the transmission debt and things of that sort that deals with the 1/3.
From your comment, as I understood it, you're not saying that lost revenues is the only just and reasonable approach. You're just saying that the particular approach chosen here is not just and reasonable.
We certainly believe that the fundamental principles underlying the lost revenue approach, which is that you need to keep remaining members whole, and by whole you have to see what the revenue stream it could be expected minus the amounts that can be mitigated. We do think that is required. Having said that, if the court thinks that's not right, we still prevail because there's two aspects of FERC's orders here. One is the 205 order, which is they rejected what we submitted, and that was our burden to prove that that was just and reasonable.
Is that challenged, by the way, the rejection of that?
We challenge, I'm going to say it very carefully, we challenge their rejection of the lost revenue approach methodology. We do not challenge every specific criticism they had of the specific variant of the lost revenue approach that we submitted to FERC. So we're not asking the court here today for an order setting aside both these orders and directing that they adopt the exact, with all the commas and periods of our lost revenue approach. We are asking, however, that the court make clear that the principles underlying the lost revenue approach must govern a just and reasonable methodology. If this court is not willing to go there, at least set aside.
Excuse me.
Sorry.
Wasn't it FERC's position that the reason that they didn't use the lost revenues is because your contract, unlike the contracts in many of the other cases, allowed for withdrawal from the cooperative without with calculated penalties. And so a breach of contracts theory like lost revenues, FERC decided was not appropriate here.
Well, I will say, I don't read their orders to say that our WESCs allow for early quitting of the WESC, but if Your Honor reads their orders that way, that would just be a very clearly wrong. I would ask the court to look at our WESCs. It's on Volume 1, Appendix 101 through 111. It is clear as day that says you have to take all your requirements until 2050, then you can give 2 years' notice and no longer be part of the contract. If you're reading their orders as saying that there is no requirement to stay in that contract to 2050, and I don't read their orders that way, but if that's what they're saying, then that would be yet another reason to vacate their orders on review, because there is just no way possible to read the WESC as saying anything like that.
Right. To follow up with Judge McHugh's question, then, are you saying that there's a breach of contract?
No, Your Honor, just like in the Norwood litigation that went to the First Circuit, the parties here, just like the New England Power Company in Norwood, came to FERC to resolve how to get out of the contract in a just and reasonable manner. So you don't need a breach of contract methodology, and I think the verbiage, I think that the breach of contract verbiage tends more to obscure than to enlighten. You can put aside that wording and say it's contractual reliance interests. It all leads to the same result.
Different parties, different contract in Norwood. It's not exactly a overlap here.
The principle is the same, though. I mean, the First Circuit says in Norwood, the fact that the methodology approved by FERC, just and reasonable, looks like a damages calculation under contract is not a problem. That's what the First Circuit said. So, I don't want to get wrapped up around the axle of saying this is a damages or things of that sort. The bottom line is that, and FERC concedes, a just and reasonable methodology has to avoid cost shift. In a cooperative context, as this court well explained and shown, cooperative context, not shifting costs, means honoring the expectation interests of the other members of the cooperative.
Counsel, if you're relying on contractual principles and saying that the commission failed to honor your contractual principles, where in your bylaws or the energy services contract should we look to extract these principles? Because I looked, I may have missed it, to see if there was anywhere written down that spoke to a methodology for termination payment.
Right, so the WESCs, which I just spoke about to Judge McHugh, do not allow for an exit before 2050. After 2050, if you give 2 years' notice.
What about the bylaws?
The bylaws allow an exit from the cooperative. And in fact, the bylaws say that the exit, that even if the board approves your exit, you still have to honor your contracts. So under the bylaws, the WESC isn't terminated. Now, as a practical matter, the board, which is the counterparty of this contract, has in fact negotiated in tandem with member exits a reasonable way to allow members to get out of their WESC contracts. But as a matter of the plain text of the bylaws.
Is there anywhere
Yes.
in the bylaws or the WESC contract where it requires a lost revenues methodology?
No, Your Honor. That has to be a just and reasonable methodology. And FERC concedes in its brief here and in the orders that a just and reasonable methodology must not shift costs to remaining members. They concede that. They then concede that their balance sheet approach does not account for 2/3 of our costs. Their only answer is right sizing will deal with some of the 2/3 of that, which means that some of that 2/3, we think most of that 2/3 is not accounted for. That's a cost shift.
Well, you admit that right sizing will account for some of those, don't you?
For some of them, and in our methodology, we have some mitigation measures. In the more complex formula we first submitted to FERC, we had even more mitigation. And they turned that down because they said, well, that was too hard to understand. But certainly on remand, FERC can adopt a methodology that doesn't shift costs, that includes more mitigation than we submitted in our simplified lost revenue approach. But what they absolutely can't do is say, we're going to adopt a methodology that only accounts for 1/3 of your yearly costs. Then for the 2/3 of costs, we're going to wave our hands and say, you can right-size some of those, so that's not a problem. In their brief here, they say, well, they can right-size many of their costs away. They're careful lawyers. There's a reason they said many, because they know they can't say all. And we think it's not even close to all, and we think it's not even close to most. But regardless of what that is, they have shifted cost to us by adopting this completely unprecedented, myopic methodology that only focuses on 1/3 of our yearly cost. That's a cost shift. Now, with regard to contracts, it is true, Your Honor, and this is an independent argument from my cost shift argument, that we don't have a contractual term here that allows for an early termination, which means that you can't terminate. So in order to allow for getting out of the most important term of the contract, which is the years, the FERC had to pay due respect to contractual principles, and that's under the Morgan Stanley case. That doesn't mean they have to adopt a damages methodology, but they have to give that due respect. They gave that no respect, no weight whatsoever. You get the exact same calculation for your exit fee under FERC's methodology if you've got 40 years left on your WESC or 3 years. They give that no weight, and giving no weight to a mandatory consideration, as announced by the U.S. Supreme Court, is a clear violation of the Federal Power Act, and it's also textbook arbitrary and capricious rulemaking under State Farm. State Farm says that if there's an important aspect of the problem, you must reasonably consider it. Surely, and as this court's decision in Shoshone well shows, the length of the commitment, which is the fundamental commitment that allows us to plan in the future, both to taking on debt to construct generation and transmission facilities, and to fund those yearly 2/3 operations, is the length of the contract. To give that not some weight, not weight compared to other factors, but to give that zero weight, to have a methodology that doesn't care about that, is a clear violation of the Federal Power Act and the APA. And on remand, if they want to try something, if they want to give a shot at something else, not lost revenue, not BSA, we can take a look at that. But what that can't do is give no weight to the long-term nature of these agreements.
Counsel, one of the responses of the commission is that, or purposes of their methodology as they explain it, and as I understand it, is they're concerned that Tri-State is essentially going to receive a windfall or more than would be otherwise gained without the termination. And I hear your argument to be that their methodology is not just going to not make you whole, but it's not even going to make you close to whole.
That's right, Your Honor.
So that's a pretty large gap here in the methodology. So can you help me understand why the commission is wrong about their concern or purpose of Tri-State receiving more than would otherwise be due?
Yeah, I mean, I think ultimately their problem isn't the lost revenue approach in that case. I think they're just not happy with how we calculated both the default and the mitigation on that. I think it, and I'll hear what they have to say on rebuttal. I think if the revenues that were expected are fully calculated, and then the mitigation measures that we reasonably can take are fully calculated, it can't be said that we have a windfall. Now, in the first version of the lost revenue approach,
let me stop you there. Didn't the ALJ calculate that if every member were to withdraw, Tri-State would generate $9.1 billion, nearly double its total assets of $4.9 billion, and nearly double its total liabilities of $4.9 billion, and it would nearly triple its total debt of $3.97 billion. I mean, it seems to me that one of your problems here is maybe you reached too far on your first proposal.
well,
And ALJ found that it was not reasonable, just and reasonable.
Well, Your Honor, a couple of responses to that. One is this hypothetical of everyone withdrawing from a cooperative. There's no cooperative then. It doesn't exist anymore. We're just done. We don't have an independent existence. We're a nonprofit. But to the extent that the ALJ has a point there and that we overreached or whatever, especially in our second submission where we had to take out our mitigation measures because they thought they were too complicated, well, then we'll lose our 205 case, but we certainly win our 206 case. We certainly, if what we submitted was reaching too far, didn't build in enough mitigation, had the rates at too high, didn't sufficiently account for the variability in the demand that the departed member would have, rule against us on the 205 appeal, but then we absolutely must win under the 206 appeal. Even if we overreached in our submission, it then, under 206, becomes FERC's responsibility to propose a just and reasonable methodology. And you can't have a just and reasonable methodology that ignores 2/3 of our cost and doesn't even purport to claim any solution for them. Now, I only have a minute and a half before my rebuttal. I would like to talk for just very briefly about the transmission crediting issue. The transmission crediting issue deals with, if the court disagrees with me on my fundamental submissions here, what the transmission credit makes sense for is that for certain, when the exit party member has to pay under their approach the debt for the transmission debt that we got, they shouldn't have to pay again if they take transmission service and that portion of that service that pays for that same debt. We don't dispute that within the context of the flawed approach. But what can't happen...
And that would be only in-network, right?
Yes.
That would be only in-network.
Right. And what it...
Okay, so and I'm trying to understand your argument is that with respect to the out-of-network costs, that there's no chance of double recovery on that.
No chance of double recovery, and that's our argument in the second case. And we have a different but related problem in the first case, is they're allowing them to use the credit for the portion of the transmission payment that relates to services and not debt. So they're messing up both halves of the equation. So we have a methodology here that accounts for only 1/3 of our costs. And then within that, it essentially guts what we're going to get paid for transmission debt, which is 40% of the 1/3. If I may reserve the balance of my time?
Good morning, Your Honors.
Good morning.
May it please the Court, my name is Jessie Halpern, and I represent Basin Electric Power Cooperative, intervener in support of Tri-State Generation and Transmission Association, Inc. in these proceedings. Tri-State's counsel has already framed the case for the court, and I would like during this time to focus on the Eastern interconnection aspects of the methodology the Commission established. The order on initial decision is, as Tri-State has explained, arbitrary and capricious, and as the Commission itself has acknowledged in its order on the initial decision, incomplete, which means it cannot be the product of reasoned decision-making. In the order on initial decision, the Commission states that it order, and I quote, leaves Tri-State and withdrawing members in a situation where an Eastern interconnection member would have no resolution. Despite that recognition that its order was incomplete, the Commission nonetheless directed Tri-State to use the Commission's established methodology and provide binding contract termination payment estimates to all members, starting with the 2024 annual update. Given that the Commission declined to address the issue of the Basin Electric Tri-State contract, that directive was an impossibility for Tri-State. Even if you ignore the procedural challenges to the subsequent orders, the fact remains that none of them provide an actionable process by which Tri-State could calculate the exit payment owed by a withdrawing member in the Eastern interconnection. And this court should not permit the Commission to place utilities or their customers in such an uncertain and unstable position.
Counsel, can you help me understand how your position here as an intervener overlaps with what I understand to be ongoing litigation before the DC Circuit?
The two proceedings are separate. The case before this court addresses Tri-State's contract termination payment methodology and whether the Commission's orders establish a just and reasonable methodology, whether it's well-reasoned or arbitrary and capricious. The orders before the DC Circuit are, according to the Commission, needed only to determine whether a reduction in Tri-State's requirements following a Northwest rural exit would cause Tri-State to breach the Eastern Interconnection contract with Basin Electric. And in the DC Circuit, the Commission has stated that it did not need to determine what the terms of Section 9, which we've referenced in some of our briefs, should require, only that the reasonable terms and conditions didn't preclude Tri-State from implementing an exit methodology.
Did FERC say, oh, please, after you, Judge McHugh.
Aren't they sort of inextricably intertwined in the sense that in order to determine the methodology, it's pretty relevant whether it's a breach, isn't it? I mean, you might have a good argument for a lost revenues methodology if in fact they're in breach.
I would agree with that, but I would note that the Commission could have established a process for addressing this issue that was transparent and workable for Tri-State, its members, and for Basin Electric, but elected not to do so here. And so the Commission early on in these proceedings determined that the Basin Electric Tri-State contract was irrelevant and simply declined to deal with it until you move on to the second set of orders that we're discussing today. And like the first set of orders, those are problematic, and they're problematic because they rely on post hoc rationalization, and they also fail to afford full weight to certain key provisions of the Basin Electric Tri-State contract. That the Commission, while attempting to rationalize the methodology it previously established in the order on initial decision and related rehearing order, the Commission failed to consider the reasonable terms and conditions language. And in saying that the decision in the complaint order was relevant, the Commission contradicts its own discussion in the complaint order. My time is almost up, so I'd just like to finish by saying that this case begs for a complete reset. Vacating and remanding these proceedings would allow FERC the opportunity to reach a thoughtful and reasoned decision on an appropriate and actionable contract termination payment methodology that takes into consideration the totality of the relevant facts.
Thank you, Counsel.
Thank you, Your Honors.
Good morning. May it please the court.
Good morning.
I'm Carol Banta for the Federal Energy Regulatory Commission. We've agreed to share, as you noted earlier, 5 minutes with Mr. Bay for United Power. I would like to begin with going back to the tri-state argument because it is the bulk of the case. And I want to bring the focus back to the Commission's role and responsibility under the Federal Power Act, and in particular, the necessary emphasis on cost causation. And I think this will tie to many of the court's questions to Tri-State's counsel, because I want to talk briefly about cost causation and cost shifts. When the Commission talks about cost shifts, it means that a withdrawing member must pay the costs incurred or obligated for its benefit, and that is its pro rata share of the collective costs. If other members end up paying some of that, it's a cost shift, and that would not be just and reasonable. So that goes to the debt, which is not merely a snapshot. It encompasses the entire history up to that point, and represents all of the pro rata share of all the debt that has been undertaken to that point, and some of the obligations for the future. When my friend talks about cost shifts, he's talking about the remaining members' shared operational costs going forward for service that they would still be receiving. So those costs may be spread over a smaller denominator. If a party is allowed to leave, which is another issue I want to discuss, once we've determined that a member can leave, then there may be fewer members, and to the extent that costs are shared throughout the cooperative, the denominators can be smaller, just as when members join, the denominator gets larger and the costs go down. but they're not paying for the withdrawing member's share of anything, because the withdrawing member is not causing those costs going forward. Tri-State's theory of causation is if you would have been there contributing in that denominator and now you're not, that's cost causation, and that's no definition of cost causation that the commission has used. You're not causing it, except by your absence, they're sharing them differently. But that doesn't go to the Federal Power Act's cost causation principle. So that's why we seem to be talking past each other when the commission says this won't shift costs, and the petitioners say, well, our denominators are going to be smaller, so of course costs might go up to the extent, of course, again, it's very important that there is a 2-year period, which didn't exist in Norwood or any of the other previous cases. There's a 2-year notice period in which everyone can adjust how they're going to operate going forward. And the ALJ took witness testimony from all the parties and considered a lot of the evidence and cited that evidence, certainly more than a scintilla, certainly meets the standard for substantial evidence. And the commission explicitly relied on the work that its administrative law judge had done in corralling all that evidence and considering it and saying that you can right-size your operations in 2 years, which again, the 2-year period is something that Tri-State itself had proposed. That a 2-year notice period would let everybody get a lot of work done in that time. And that goes to the other issue I wanted to address, one of the other issues I wanted to address, about the ability to leave. And the suggestion that this case is about the commission's deciding that a member can leave the cooperative. That ship sailed a long time ago. Those are previous orders. I mean, that's already being talked about in the show cause order that gave rise to this proceeding that we discussed in the background of both of our briefs. The hearing order that set this for the administrative law judge. When the cooperative, when Tri-State chose and actually worked pretty hard to become FERC jurisdictional, FPA jurisdictional, one of the things that the commission came to early on is your bylaws say that you can leave, but they don't say how. And one of the requirements of the Federal Power Act is transparency. You have to have procedures that are clear. And you have to have a calculation methodology that is clear and predictable so that parties can understand whether it's in their interest to leave, members can understand whether it's in their interest to leave or not. And maybe they wouldn't have had to do any of that if they weren't FERC jurisdictional, because when we talk about the cooperative model, and the commission did talk about this, and I do want to point to a couple places in our order, in the commission's order, obviously. For instance, in what we've called the methodology rehearing order, the May 23rd, 2024 order, paragraph 23, which we did cite, we may not have mentioned this sentence. The last sentence cites back to something that's also in the first order, you can cross-reference it there, where the commission had found in yet another tri-state case that isn't before this court, that when we're talking about the cooperative economic model and the sharing of those costs, the commission has found that the characteristics of the cooperative business model itself do not justify departure from the well-established cost causation principles. So, yes, cooperatives can be a different animal, and Congress recognized that 80 years ago when it exempted them from the Federal Power Act and the rural distribution cooperatives. And I'll note that all the parties in the case except FERC are rural cooperatives. It's not just Tri-State, United Power is as well, and the other interveners on the commission side. They're all those distribution cooperatives and public power districts are exempt from having to meet the cost causation standards under the Federal Power Act. And Congress had its reasons for that. But occasionally, a generation and transmission cooperative is a larger collective of those small ones. And as long as all the members are non-jurisdictional, so is the generation and transmission cooperative. But for reasons that go beyond this case and into quite some history, sometimes a cooperative like Tri-State decides it would rather be FERC jurisdictional, and it does something here. They let in members that don't qualify. So they took themselves out of the FPA jurisdiction. Well, now they're subject to the FPA standards. And FERC does cost causation all the time, and courts do cost causation all the time. It's not an aspirational principle. It is a core requirement of just and reasonable rates under the Federal Power Act. And the fact that you might have been able to do something that wouldn't meet those requirements under the cooperative model, well, if you're exempt from the Federal Power Act, we're not having this conversation at all.
Counsel, can I ask, you just said that applying the cost causation principle is something FERC does all the time. But yet, as I read the briefs here, the methodology you came up with, I think, was for the first time. So how can we square the argument or position that this is sort of rudimentary commission work with now saying we're going to apply this new methodology that, even though we've never said you can't do it, we've never done it before. This seems to be something new.
Sure, and I didn't mean to suggest we've done this methodology all the time. It does, I mean, certainly the commission does have extensive expertise with the financing and operation of transmission and generation and all of that. It's just that I was making the point that when we're talking about cost causation principles, which the commission gave a lot of thought and spilled a lot of ink on in this case, how to apply it here. And it is an unusual case. We don't have a lot of cases where we're setting an exit fee methodology for the kind of entity that most of the time is not within our jurisdiction, but this one is. So we're applying the principles that we always apply, and that's why the commission talked a lot about, and going back to what I was saying about what cost shifts are, and the commission talked a lot about trying to balance, making sure there isn't over-recovery and under-recovery. These are all the principles that the commission uses all the time. So yes, this is an unusual situation. We don't have a precedent for this. And none of the cases that Tri-State cited are precedential for this, because none of them were setting an exit fee, a uniform exit fee methodology to be put in an FPA jurisdictional tariff going forward. But that doesn't mean the principles aren't the same, and it doesn't mean that the commission's expertise and its administrative law judge's careful work doesn't apply a lot of the same things. Certainly, the commission understands regulatory accounting, its reliance on its standardized form that I think pretty much possibly all of the FERC-regulated entities use. It talked a lot about we want to make sure that the withdrawing member isn't overpaying. It's not just that. The commission also talked about, even if it's not that withdrawing member overpaying, does this result in Tri-State over-recovering its costs in general, but also under-recovering? That was a huge part of the commission's analysis here, was also making sure that Tri-State doesn't under-recover its costs, and that's why there's the emphasis on making sure the withdrawing member pays its pro rata share of all the debts and obligations, both generation and transmission, and dealing with that.
Council, one of the principles that comes up in the briefs, particularly on Tri-State, is the idea that they need to be made whole. I'm going back to the first point you were discussing about when the denominator changes and the number of members, then the costs will differ. Does the commission, first as a principle, agree with this made whole argument, which I think I know the answer to, but I'll allow you to say it?
No, I mean, it is a model of breach damages, which the commission explicitly found doesn't apply. It's not about making sure that no remaining member ever pays a dime more than they would have if you had stayed. It's about making sure that the costs that the withdrawing member caused, the debts that were taken on to serve it, that it does not dump those costs on someone else. It bears those costs.
But Tri-State, I think, is arguing that within the contractual relationship between the cooperative and its members, that if you look at the bylaws and energy services contracts, that you have to extract from that this made whole principle, and that the commission needs to respect that. So why is that argument?
Right. Well, as Your Honor noted, there isn't language that actually specifically requires that. But I would point to what the commission did say here, and this is in the first order we're talking about, the methodology order, the order on initial decision. At paragraphs 28 through 230 is really where the commission grappled with that. And it looked at a section of what we're calling the WESCs, the requirements contracts. Section 8 does not directly address the fee that a withdrawing member should pay. But it does mention paying a pro rata portion of outstanding indebtedness on the notes, as well as other obligations. And then in section 220, or paragraph 229, the commission looks at the bylaws. And again, when Tri-State became FERC jurisdictional, these bylaws that had just existed among the cooperatives now needs to be a tariff. It needs to be something that is public and transparent and approved by the commission. So we're looking at the bylaws in paragraph 229. Oh, I'm sorry, we're actually still on the West. I think the bylaws maybe in a different place, but in the, yes, the preamble, in paragraph 229, the preamble to these requirements contracts that the commission was looking at, where it specifically mentions the financing of facilities being a shared obligation. So this is where the commission comes to the understanding that you cannot shift the costs of your pro rata share of the debt. You have to pay your pro rata share of the debt. And so the commission did look at all of that.
So I don't want to run out of time before we also talk about the second case. And with respect to that, isn't it a decent argument that there will be no double recovery on the out-of-network expenses? Because yes, they would get double recovery if they continue on the in-network, but not on the out-of-network. So why is it appropriate to credit back all of it? Is that question making sense to you?
Yes, yes. And where the commission really addressed that is in the last order we're discussing what we called the compliance rehearing order of April 29th, 2025, in paragraphs 28 and 29. And that's where the commission, and we pointed in our brief that actually, let me take you to a different order if you'll indulge me. The initial order that I was just talking about in a different part of it. In paragraphs, actually, we're leaping around among all these orders. It's the methodology rehearing order, the May 23rd, 2024, that has language about, well, it's one of these two orders has the language about United Power having raised concerns, and the commission said these concerns, and in our brief we laid out, we said there were always two concerns. And one was a withdrawing member having to pay twice. But the other concern, well, we have three concerns because it's a balance. And as I said, we're always concerned about making sure that Tri-State doesn't under-recover the no stranded costs. That concern is on this side of the balance. But the commission said that there are two concerns on the other side of the balance. And one is that the withdrawing member doesn't, and I did find it, it is in the first order, and it is paragraph 564. And the commission was responding to United Power, because United Power, of course, is concerned about the we're not double paying part. But the commission says, divides this into two things, that there's recovering the costs twice, and that could be from anyone. And the second is making sure that the withdrawing member gets the full benefit of its prepayment so that it hasn't overpaid. So from the start, there were two concerns, and I know I'm actually maybe making this more confusing. It's not just about the withdrawing member paying twice. It's that you also are getting money from other places. And that's where we go to the last order, where I actually had started with the compliance rehearing order at paragraphs 28, 29. And the last sentence of paragraph 28 in particular, when the commission says, if you didn't credit the non-network amounts back, you would permit Tri-State to recover on debt on the non-network facilities, both from the withdrawing member and from its remaining members and its member rates, because they're continuing to pay those going forward. And so you still could end up in a situation where Tri-State is double recovering. And it's not, and it's not double recovering, like recovering more than just the actual costs that we want to make sure they don't under-recover.
Well,
It is
doesn't
very
that give a
confusing.
bit of a windfall, to the withdrawing member?
No, first of all, they only
But
get,
they get a credit for something that they're not double paying.
well, they did pay it up front. And even if
Yes,
it's,
paid it once.
even if it's not in their OAT, I hate to use the acronyms, their open access bills, they are still, if they're getting any credit at all, they are still using the facilities. And they've paid for some of the facilities that they needed to serve themselves, they paid directly for those. That's addressed in paragraph 29 as well. So first of all, you
When you
don't,
say some facilities, do you mean in-network?
no, they're still benefiting from the non-network, is my
And
understanding.
they paid for that in their original exit fee, right?
Right.
But there's no risk, as I
Well, this is,
understand it, and maybe confused, that somehow Tri-State is going to receive a double payment from them for the
Right.
the out-of-network facilities.
and it's not,
Am I understanding that correctly?
you're understand, I think you're understanding the arguments correctly, but it is not about double recovering it from the withdrawn member. It's about double recovering it at all. So you recovered the withdrawn member's share of that lump sum of the non-network transmission debt. And there's no argument that that is included in the prepayment, and certainly Tri-State was not confused about including it when it calculated, for instance, United Power's withdrawal. But those amounts are still being collected in the member rates that the members are paying. So it is confusing. And it is also a bit of the tail wagging the dog, because the numbers in the briefs reveal that the network facilities are something like 4/5 of that upfront payment. The non-network is a relatively small compared to the network facility number. And I do have those numbers if the court wants them, but I think it was something like nearly $1 billion of the total transmission debt for network, and then like 300 million, 200 or 300 million for the non-network.
Counsel,
Lump sum, not what one member is prepaying. Yes?
Tri-State's beginning argument was that they are under-recovering under your methodology because 2/3 of the costs don't show up on their balance sheet, what I'll call O&M, operation and maintenance type cost. Is that right?
Well, what they're talking about, well, I don't know if that number's right, but what they, I think it's probably right. But that is costs going forward, operating cost each year. It doesn't account for the fact that the withdrawn member paid its pro rata share of the debt before it left. This would be the amount that the remaining members are paying each year going forward. And again, that goes to the right sizing issue and the ability to reduce those costs with a couple years of lead time. But in addition, what I started with the cost shifts, if those ordinary costs of running the system and the insurance and whatever costs couldn't be right-sized, are being shared among the members who are benefiting from those services going forward. But the denominator of how many members are sharing those costs has gotten smaller. That is not a cost shift. That is, in the commission's language, that's a function of membership. That just means the denominator goes up when you get more members and goes down when you get fewer members. But those costs of serving the system a couple years after a member withdraws aren't caused by that member. Tri-State's theory is that it's caused by that member's absence of not being there to be in the denominator, and that's back to where we started.
Does the withdrawing member pay all their pro rata share of all costs incurred before they withdraw?
Yes, that is a lump sum payment. I believe it's on the date of withdrawal. They're given their exit fee amount when they give notice, and then they spend 2 years ironing out a lot of things, Tri-State downsizes or right sizes, and the parties nail down exactly what they're doing about power purchase agreements, which is something that has not come up in this case but was dealt with extensively before the commission. And at the end of the 2 years, you pay your lump sum amount, which is quite substantial. And if you continue taking service as a customer, then over decades, you get some of that back. Although I do want to make another point about the transmission crediting mechanism I didn't mention earlier. It's quite easy to forfeit some of that because it is apportioned monthly, but if your monthly bill is less than the amount of your credit, the commission said that's forfeited, that Tri-State keeps that. But yes, you pay on the date that you leave.
On the issue of the credit, not a lot of citation there to the record as far as what the substantial evidence would be. It just is there, the credit. Can you respond to that and say why we should say that there is substantial evidence to support the credit?
Yeah, and I think that was largely United Power's argument in its petition that it withdrew, because it didn't especially like this either. In the first order, the commission talked about that the ALJ had taken proposals from everyone, and I believe I know trial staff had proposed including transmission debt up front. Not all the parties before the administrative law judge wanted to include transmission debt at all. They were just talking about generation-related debt. And the administrative law judge said, no, you got to include all debt. But we do have this potential for over-recovery, which we don't have with the generation assets, because you paid your share of that. Nobody else is using that, your share of that. There's no issue with that. But with transmission, there is an issue of potential over-recovery. And so the trial staff had proposed something that the commission just found too convoluted. It wasn't workable. It involved making projections into the future that just weren't.
The offset.
Yeah, the offset. So what we had in the record was everything about including transmission debt and having to find some way to prevent over-recovery. And I think that the commission's determination was largely based on just understanding the principles and mechanics of over-recovery and under-recovery and trying to balance those concerns. And it came up with something that, again, you can forfeit the credit if you don't use enough of the service going forward. That's balanced against the fact that you get the credit, but it takes decades because it's amortized over time. So it's a bit of maybe a rough balancing, but it was to solve a problem that no one had solved in a workable way, and some of the parties weren't even proposing something to resolve. But I do think that the potential weakness of the commission having come up with it itself was largely United Power's now withdrawn petition for review. I know I didn't get to Basin, but I think the court understands the issue well, and that the DC Circuit has exclusive jurisdiction of the orders, which really did get into more than just there not being a breach. And the commission here was just saying, don't treat the exit fee as being based on a breach, and follow what we've found in the other proceeding, which the commission knew about as early as the rehearing order, methodology rehearing order.
Judge McHugh?
I have one too, but I'll wait until after you.
Just quickly, my understanding from, I don't remember which brief, is that maybe on the 7th compliance filing now at this point, in the second 2 consolidated appeals, we're reviewing, as I understand, orders from the 2nd and 3rd compliance filings. So if this process is continuing to be ongoing, I guess I'm just asking for our purposes, because we're going to have to decide and write an opinion. Do you anticipate these additional compliance filings and all this shifting this litigation at all?
I think if the court were to affirm the commission's orders in the cases before you today, my understanding is I think the disputes would largely go away. I would note there's yet another pair of cases before the court right now. Case number, I want to say 259583 and 9594, but I'm not positive I'm right about that are in abeyance, because I think everyone understands that they will be largely governed, if not entirely resolved, by what the court does here. But yes, that goes to how much time. This was really a process where the commission put out a lot of orders considering all aspects of this, but also has had to tell Tri-State a number of times when we said the full amount of the debt and the full time value, and including the non-network, we meant it the first, second, and third time.
And my question is a little bit, it sort of is the same, but a little more specific than Judge Federico's, which is if the DC Circuit were to rule that it is in fact a breach of the basin contract to withdraw before 2050, would you have to go back to the drawing board and redo everything here?
I think that would only apply to Eastern Interconnection members, so it would be an unusual, I don't think it has to affect this case, because here the issue was whether the commission had addressed the issue, and the commission understood that there was a separate proceeding where that would get handled, and if it got remanded to the commission, then the commission would look at it again. The Eastern Interconnection members have always been in a little different position because they have no generation debt. They're not making the kind of large payment upon exit that was really the bulk of the concern here. And that was always the tricky thing about it. It is going to be about that contract, but I don't think it has to affect this case, even if it could affect what the methodology would be for some Eastern Interconnection members. I think that's my understanding. Yeah.
Thank you. All right, thank you, counsel.
Thank you.
Good morning. May it please the court. My name is Norman Bay, and I represent United Power. United Power is a member-owned, not-for-profit, rural distribution electric cooperative located in the northwest of Denver in the Front Range and has a service territory of 900 square miles. So I'd like to provide United Power's perspective on these proceedings. First, United Power exited pursuant to rate schedule number 281, which is a tri-state tariff, right? So United Power did not breach a contract and said it sought to exit pursuant to the procedures delineated in rate schedule number 281. So there was no breach of contract, and that's why breach of contract damages are not applicable. Because rate schedule number 281 involved a rate, FERC had the obligation under the Federal Power Act to ensure that the process and the rate itself were just and reasonable. So in order to do that, FERC relied upon a fundamental principle, which is to say the principle of cost causation. Here, what FERC said was that Tri-State should be compensated for the costs it had incurred to serve the member or was obligated to incur to serve the exiting member. So that's the principle that FERC applied. And what Tri-State then did, though, was to propose a variety of ways of basically receiving compensation from the exiting member. In its brief, it insisted that the only possible path forward was based on the lost revenues approach. But in fact, in April 2020, Tri-State's first proposal was called the mark-to-market make-whole methodology, which it rejected after FERC criticized it. Tri-State withdrew it, and then it proposed what it called the modified contract termination payment approach. But even that had the lost revenues approach, the debt covenant obligation, or the higher of those two approaches, although in this appeal, as Judge Phillips noted, they aren't even trying to defend the DCO or the higher of approach, even though they had presented an integrated methodology to the commission. In other words, Your Honor, they're cherry picking. They've changed the proposal they originally submitted to FERC. And as Judge McHugh noted, there was overreaching here because the total amount of payment would be $9 billion if all 42 members exited. You know, if you were just to look at the members that did exit, for United Power, it would have been $1.6 billion. For La Plata Electric Association, it would have been almost $500 million. And for Mountain Park Electric, it would have been I think 167 million. The total amount from those 3 members alone would have been 2.25 billion, which was 60% of the total debt of Tri-State. So yes, was there overreaching? Yes, and that's what the commission was reacting to. So what the commission did instead was to adopt an approach that it wanted to be transparent, replicable, and formulaic. Okay, and there's a very important note here, and why? Because transparency is very important, and Tri-State had been unwilling to provide the exit fee to members who wanted to depart, okay? And so what FERC came up with was looking at the debt on FERC form number 1. So it's, in other words, it's data that's publicly available, reported by Tri-State, and then figuring out each departing member's pro rata share of that debt. Again, so that's transparent, replicable, and formulaic. When you look at the commission's April 29th, 2025 order, the commission says this, Tri-State, and this is in paragraph 32, Tri-State has repeatedly failed to comply with the Commission's compliance directives and provided incorrect CT estimates to its members. And then it says, Tri-State's approach would potentially require further Commission proceedings each year to verify the allocation factors. The Commission notes essentially that the administrative burden would also not be limited to the initial adoption of the CTP methodology. In other words, there would have been this enormous administrative burden if each time Tri-State came out with a number, there was collateral litigation, both at the Commission and ultimately in the Court of Appeals. And so the Commission came up with its approach, the balance sheet approach. Again, transparent, replicable, and formulaic. Now, Tri-State has made a number of arguments saying that it could not downsize or right-size its system, but that's why the Commission agreed to Tri-State's proposal that there be this 2-year notice period. That was Tri-State's proposal, and that notice period was to give Tri-State the opportunity to right-size its system. Tri-State did provide evidence at the hearing before the ALJ that said that about 2/3 of their costs were fixed costs and 1/3 were O&M operations and maintenance related costs, which was your question, Judge Phillips, like what are these costs about, right? Tri-State's saying that the 2/3 number was fixed costs. But you know, in the Seventh Circuit decision, MCI, the Seventh Circuit noted that in the long run, there are no fixed costs. All fixed costs are variable costs. What does the Seventh Circuit mean by that? United Power's witness, Geffert, testified that, and so this is all in the record, that what you do if you have a plant that's not recovering O&M is you either ramp back operations or you retire it or you accelerate its retirement. If a member has left, you don't go out and get a power purchase agreement to buy power for a member that's not there. There are things that you can do to reduce your fixed costs. You optimize your fleet. And the record also showed that of the 8 power plants that Tri-State owned, 3 were going to close in the latter half of the 2020s or in the 2030s. Only 1 plant was estimated to still be running by 2050. So some of these plants were old. And oh, by the way, there was a 4th plant that had a number of units, most of which were going to retire in the 2030s. So again, this is Tri-State's own evidence that they submitted to the commission before the ALJ. And so what do you do then if you've got these fixed costs? Well, you start doing what United Power's expert testified you would do. You start downsizing. You start basically mothballing units that are no longer economic, particularly if the power is no longer needed. Let me turn to the second issue, and that is the transmission credit. What the commission—
Let me just interrupt you.
Sure, Judge
You are
Phillips.
over time. However, we understand, and I thought 5 minutes was awfully slim for United. We'll make it up to you on the backside with the rebuttal time. So please continue.
Thank you, Judge Phillips. So now, you know, United Power has made a payment of $627 million, even under the commission's methodology. $296 million of that amount was for transmission-related debt, for both OAT debt and the non-OAT debt. The commission had encouraged exiting members either to buy their non-OAT facilities, which are the radio facilities, the lower voltage facilities, or to enter into use agreements. United Power bought its radio facilities. It paid $75 million. So for it not to get a full credit would have resulted in double counting. It'd be like buying a car, paying off the debt, right? And then buying the car again. And so there had to be some sort of allowance for that use of the payment or payments that United Power had made. But I also want to make a more important point, actually an overarching point about this transmission crediting mechanism. Again, the commission was trying to come up with something that was relatively straightforward. And it was not just trying to address this issue of double recovery of OAT debt. That misstates the commission's order. The commission was clear that it recognized that the exiting member was making this big payment, and so wanted the exiting member to receive the full benefit of its payment. It uses that phrase repeatedly in its orders. But what does Tri-State get out of it? It gets this huge upfront payment. It has a much lower risk that its facilities would be stranded, right? Because one thing the commission was worried about is once a member exits, would those Tri-State facilities be stranded? Well, by giving this big transmission credit, right, the member has every incentive to continue to use the Tri-State facilities, which is important because for the non-OAT facilities or radio facilities, typically those only serve the exiting member, right? So the commission was actually mindful of Tri-State's concerns, just trying to balance a number of considerations. It also gave Tri-State the benefit of the fact that the credit is forfeited if it's not entirely used.
Okay, counsel, 30 seconds to wrap up, please.
Okay, so what I would say, Judge Phillips, is that this court and the Supreme Court have long noted that rate making is not a science. It's part science, but it's also part art. And the commission here was trying to come up with a process balancing a number of concerns in which its final rate would be just and reasonable. And the law is clear. A just and reasonable rate doesn't have to be a perfect rate. It doesn't have to be the best rate. It just has to be within the zone of reasonableness. And that's what the commission achieved by formulating this transparent, replicable, and formulaic process. Thank you, Your Honor.
Any questions I should ask? Thank you, counsel. All right, before you get started, counsel, let's adjust your clock. And I think to be fair and equal on the time, and I'm not saying you need to use it or that you want to use it, change it to 11 minutes.
Thank you, Your Honor. That's very generous. I've got 5 points. I don't think it'll take 11 minutes unless there's questions from the bench. First, this absolutely remarkable effort to redefine what cost shifts have meant in every other context that FERC says. I mean, Norwood, that involved a tariff, an exit tariff. Wabash, an exit from a cooperative. And then broader reasoning, American Wind Energy. Cost shift always means leaving the remaining party no worse off. This artificial distinction that counsel for FERC makes about cost shifts versus those that are remaining doesn't make sense. Let me give you all an example. Let's say in an effort to right size, because a lot of our members leave, we got to shut down a mine or we got to shut down a power plant. That's going to have environmental remediation costs. That's going to have compliance costs. That's going to have regulatory costs. Under their approach, our remaining members who didn't leave, who are not the reason this plant or mine is shutting down, they have to pay all of it. United, who gets out, times it, gets this windfall, he has to pay none of it. Those facilities were built in part to serve United. United leaves, we have to shut them down because they left. Yet our members who didn't leave, who are left holding the bag, have to pay all of that. They're paying none of it.
Is that established that that's the reason that the plants would be shutting down?
Well, that's what right sizing means. They're telling us, they're telling the court that don't worry about the fact that we covered our eyes to 2/3 of their costs because there's going to be right sizing. Well, first of all, and they were very careful, they're not saying it can all be right sized away. But even the right sizing itself, it's not costless. There's environmental remediation, there's compliance costs, there's regulatory costs. Their formula accounts for not one bit. And I'm going to say that again. Their formula accounts for not one penny.
Well, I just thought I heard United Power say that this hypothetical that you just proposed wouldn't actually happen because you wouldn't be left holding the bag to close down because they were still either going to use it or that they bought them. Maybe I misunderstood that.
I mean, I don't think that's what he was saying, but for example, I mean, we're going to talk about things not on the record. We had to shut down a mine. That was used to get coal to serve them in part. There was significant environmental remediation on that. They paid not a penny for that. Our remaining members paid a penny. That's what the 2/3 is. It's stuff that the system was built to serve them. They were 20% of it. And now all the stuff, both the right sizing we can do, they can't do, the risk of downsizing, the remaining members are holding the entire bag. Meanwhile, they get to have their own thing, and they already made the economic decision that they're better off doing their own thing rather than honoring their 50-year contract. And then next, this right sizing thing. Again, you heard counsel for FERC say there's a lot of work that can be done in the 2 years. Yeah, there's a lot of work that's done for planning for what we do. For example, shutting down the mines, shutting down whatever plants we have. That's going to happen in the long tail. But the actual shutdowns, the right sizing, the risks in shutdown, the right sizing, those are the 2/3 of the costs that they're not accounting for one bit, that they get a free ride for, that we built a system to serve them in part. They get out, only pay 1/3, leave the remaining members, the ones too small, the ones that are not serving, the rich growing suburbs of Denver, the ones serving folks in New Mexico, rural folks, they're left holding the bag, while the rich folks in the suburbs of Denver get out and don't have to pay any of those 2/3 costs. I didn't hear a word from FERC or from United about the first point I raised, which is that the methodology here doesn't account at all for the number of years left on their voluntary, sophisticated commitment. Not saying it has to be exactly breach of contracts damages, although I will note that the First Circuit in Norwood said that that's not a problem if the exit fee approximates that. But it is surely textbook arbitrary capricious rulemaking to take a very important consideration. This was the core consideration that this court talked about in Shoshone, which is the number of years remaining, and give it 0 weight. Not give it some weight, not we use our discretion to give it 25% weight, but to give it absolutely no weight, to have the exact same payment calculation if you leave in 3 years left or 40 years left. They didn't give that any weight. That is clear, arbitrary and capricious, and a sufficient basis to vacate.
Didn't give it any weight in the sense that it never came up and it wasn't considered, or you just think that it deserved more attention than it got?
They do not account for it in any respect in their formula, in any respect.
But was aware of it?
It was aware of it, and it gave it, they created a methodology that gives it no weight. And the reason doesn't make sense for giving it no weight. For treating, and we put a hypothetical in our brief that they didn't respond to. You all can look at it. It just shows how absurd it is to give that very important consideration no weight in how the formula actually plays into
What was their reason?
They didn't give a reason. They said we want to do this other thing because it's more transparent or something, and because they didn't like the numbers.
I just thought a moment ago you said their reason for not taking it into account didn't make sense. So I wanted to know if you could.
So the reason that they shifted to the balance sheet approach, which doesn't take it into account by definition, was patronage capital and the fact that they'll still be taking transmission. That's not a reason not to take it into account. That doesn't have anything to do with anything. If you look at their brief, they say it in their brief. The reason that we went with the balance sheet approach, which is a balance sheet approach doesn't take this into account. The reason we went for it is because of patronage capital and because of the taking of the transmission credit debt, transmission service after we leave. That has nothing at all to do with why you would not take this consideration into account. It's completely orthogonal. Then briefly on the credit, they're saying, they quote this language in the order on ID that says that you should get the full benefit of they should get the full benefit of the credit, of the payment that they made. But that's just another way of saying that they shouldn't have to pay for transmission debt. That's what full credit means, and their only answer is, well, you might be able to forfeit it. Well, that just means that the big boys like United, who have the big payments, who take a lot of transmission, are going to get the free ride, and maybe the smaller ones, they're not the ones not serving not serving growing suburban Denver, are going to take some loss. But the saying that you should get the full benefit of transmission credit, why not give them the full benefit of the payment they made on generation then, and let them credit away their entire payment? It makes no sense. It's just an assertion. And finally, I'd like to end kind of where my friend for United ended, which is just and reasonable. Taking a step back, we have a cooperative here. Everybody, including United, committed that they were going to take all the requirements for 50 years. That was to fund not only the 1/3 that's debt, but the other 2/3 and all the risks in between. There's no sense of just and reasonable where the remaining rural members in New Mexico get left holding the bag for those 2/3 costs, with their only answer from FERC being, well, some of it will be able to be ride-sized. That is not just and reasonable. If the court thinks that we overreached or whatever, don't rule for us on our 205 appeal. But surely on the 206 appeal, what was adopted here is not in the universe of just and reasonable. And for that reason, I would ask your honors to vacate the orders on review.
Any questions? All right, thank you, counsel, and thank all of you, counsel, for your helpful and excellent arguments. The case is submitted. Counsel are excused. It looks like everybody is settled and the courtroom has emptied to the extent it's going to empty. And so I don't have my sheet in front of me that they handed me, but I do believe the next case up for argument is Vasquez-Garcia versus Centurion, docket 25-2007. Counsel, we are ready for you when you're ready to proceed.
May it please the court. Claire Saunders, representing Appellant Sandra Vasquez-Garcia. I'd like to attempt to reserve 3 minutes for rebuttal, please. The question in this case is whether Ms. Vasquez-Garcia's complaint is consistent with an accrual date for her Eighth Amendment claims that places the filing of the complaint within the statute of limitations. The answer to that question is yes, for 2 reasons. First, Ms. Vasquez-Garcia's complaint is consistent with the theory that a reasonable person in her position would not have known that she suffered a constitutionally salient injury until she received appropriate medical care outside of prison. Her claims are therefore timely under traditional accrual principles. Second, Ms. Vasquez-Garcia's complaint can be understood to allege a continuing violation that went on from essentially the day she was incarcerated until the day that she was released. Her complaint, filed 3 years after her release, is therefore timely under the continuing violation doctrine.
How much of this is objective or subjective? In other words, do we look at it from a reasonable person in her position while in prison, or do we look particularly at what she knew and thought?
So I think it's an objective standard, Your Honor. It's a reasonable person in her position, but I think it's important that we have to take the allegations in the complaint on their face in the light most reasonable to Ms. Vasquez-Garcia. So I think the district court's
error was to draw inferences against the complaint and assume that a reasonable person in Ms. Vasquez-Garcia's position would have known things that we just can't assume that she would have known.
Does it cut both ways? In other words, you have to allege a Eighth Amendment violation, which requires a lot, and yet the accrual cuts the other way. I didn't know very much.
So, I mean, I do think there's sort of an inherent tension here, which is that the standard for making out an Eighth Amendment claim is very, very high. So, you can say, Your Honor, a reasonable person in the plaintiff's position wouldn't have known that they had suffered an Eighth Amendment violation, and that does set the bar, relatively high when they have to actually, prove facts to establish a claim for relief, and I just think that's an inherent tension here.
What did the district court do wrong in that regard?
As to the objective versus subjective analysis.
Yes, and what we're talking about.
So I think the district court took the allegations of the complaint and drew inferences against it. So for example, I have a list of 4 things that I think the complaint simply does not allege, and that the district court, I think, assumed that a reasonable person in Ms. Vasquez-Garcia's position would have known, but that, we shouldn't assume that. So the complaint doesn't allege that Ms. Vasquez-Garcia was informed of her diagnoses in real time. The complaint doesn't allege that she understood the care that she should have been receiving. The complaint doesn't allege that Ms. Vasquez-Garcia understood the care she actually received. And the complaint also, of course, doesn't allege that Ms. Vasquez-Garcia understood the defendant's mental state.
Well, counsel, if the inquiry is an objective one, and understanding the complaint doesn't really discuss at all what Ms. Vasquez-Garcia, what information she received or knew or what she thought, but I think part of the points the defendants are making is that any reasonable person who knows they're having these types of symptoms would know that once they bring it to the attention of the medical professionals at the facility, that they're not getting what it is that they should be getting. I mean, just at a basic level. So what's your response to that?
So my response to that, Your Honor, is the distinction between sort of acute and chronic conditions like diabetes. I agree. If Ms. Vasquez-Garcia had been, stabbed or had a hernia or something, I think there are instances like that in the case law, or she was choking. It's pretty clear to your average layperson what appropriate medical care looks like under those circumstances. I think the issue here and the problem with the defendant's argument is that the nature of Ms. Vasquez-Garcia's injuries was just such that a reasonable person in her position may not have understood what appropriate care looks like. I think there are people walking down the street today who probably have diabetes and don't really know what it means to have appropriate care for that, when insulin is appropriate, when it's not, those sorts of things.
And so is that also responsive to their argument that the complaint, they say, is a series of discrete acts compared with your argument towards a continuing violation?
Right, exactly, Your Honor. And on the continuing violation point, I think Herrera really sort of solves this problem. In Herrera, this court said that the plaintiff suffered their injury the moment that their access to water was cut off because of someone else's failure to pay the bill. I just don't think the nature of the allegations in this complaint are such that they can be, again, construed in the light most favorable to Ms. Vasquez-Garcia. Any individual allegation could be understood in that way. So, a failure to provide a diabetic diet on one day or even for a month, would that give rise to an Eighth Amendment violation, or, could have plausibly caused her injuries? I don't think so, Your Honor.
Right.
Well, she knew that
yes.
she was supposed to have special diet, right? The complaint does allege that she understood that she was supposed to have a special diet, and she also understood that she wasn't getting a special diet. Right then, doesn't she have information that would indicate that they are failing to provide the treatment necessary for, and I think we have cases saying that severe diabetes rises to an Eighth Amendment level. Isn't that enough?
So I think what the complaint alleges is that even a non-medical professional would have understood that she needed a special diabetic diet. What the complaint doesn't say anything about is what Ms. Vasquez-Garcia understood about the food that she was receiving as opposed to the food that she should have been receiving. We don't know, for example...
Well, she says it was no different. The complaint says she recognized that the food she was getting was no different than a regular diet. Am I misremembering the complaint?
I don't think that the complaint says that Ms. Vasquez-Garcia understood that they were the same. I think the complaint just alleges, as a matter of fact, they were essentially the same. And I realize that's, not ideal wording, but I think, giving someone who's diabetic a piece of cake for dessert versus giving them a fruit cup where the fruit is soaked in corn syrup, for someone who's diabetic, those two things might actually be equally harmful, but a reasonable person in her position may not have understood that those were equally harmful diets to her.
Counsel, what about the allegation, the complaint, I think it's in June of 2020, that she experienced vision loss and pain in her right eye, and then it says in July of that same year, she told the medical staff her eye was, quote, very painful and she had difficulty seeing. And we have case law that talks about extreme pain as
Right.
being a triggering point for an Eighth Amendment violation. Why wouldn't that allegation trigger an accrual?
So I think that allegation doesn't trigger an accrual for a couple of reasons. One, I think there isn't the appropriate causal link to the defendant's mens rea, essentially. Two, I think that series of allegations, Ms. Vasquez-Garcia began to experience vision symptoms, and she was prescribed eye drops that were essentially to relieve dry eye. So I think, again, with a 30,000-foot view with perfect hindsight, any reasonable person would say, well, if you're experiencing vision loss and you have diabetes and all these other comorbidities, it's probably not, an issue of dry eye. But the complaint doesn't say that Ms. Vasquez-Garcia understood that that's the treatment that that was what she received. She could have totally thought that the drops were of the right sort. I believe.
Agree that if she reports a serious medical condition that rises to the level of an Eighth Amendment violation, and the prison does absolutely nothing, despite her reporting this serious medical condition, that she would be on notice that she has a claim, because we have plenty of cases that doing nothing is enough.
I'm sorry, Your Honor.
To show the method.
I'm sorry, Your Honor. Could you please repeat that question?
Yes, my question is, if she reports a serious medical condition that would qualify under the Eighth Amendment, and the prison does absolutely nothing in response, isn't that enough to fulfill the mens rea requirement knowledge portion also? Because we have plenty of case law that says doing nothing meets the mens rea requirement.
Yes, Your Honor. I wonder if you're referring to Vasquez. I think I essentially agree with you, but I would say we need to also know that Ms. Vasquez-Garcia understands the nature of that the plaintiff in that case would understand the nature of the injury they were suffering. So in Vasquez, the sort of rock bottom place where the court said the claim must have accrued was when the defendant, had been told that the injury he was suffering could kill him, and then B, when a document produced in discovery showed that a medical professional sat down with the plaintiff, explained his illness and the appropriate treatment protocol at length to him, and he confirmed he understood. The court also referenced the fact that the plaintiff in that case later submitted grievances stating that he, quote, needed the treatment. And I believe there were 2 grievances in that case. So I think, I'll stop there.
On the accrual date, I think in your reply brief, you said that we can't even determine the date now. But what facts would be needed to determine the accrual date?
So I think Mallet, the Second Circuit's decision in Mallet is very helpful here. I think we need to know what the medical providers told her and when they told her. That.
That's why you need discovery?
Yes, that's right.
Well, there's also a lot of discussion that's triggered around her release date.
Right.
May 7th, and of course, the defendants say it was actually May 5th. And why does the release date matter?
So, Your Honor, for purposes of the traditional accrual analysis, I think the release date is not relevant. The release date is only relevant to the continuing violation theory. I understand that there's a dispute of fact here, but we're at the motion to dismiss posture, and, this court, the district court correctly recognized that those disputes aren't appropriate to resolve in the motion to dismiss posture.
With it being the continuing theory, as you say, what was the last act that would qualify under that?
So I think the complaint alleges that each of the defendants had an essentially uninterrupted duty to give Ms. Vasquez-Garcia appropriate medical care, and that lasted from the day that she got to the facility until the day that she left. And so I think the last act is just going to be the failure to administer appropriate care on the day that she was released.
But the last time that I believe she was saw, I won't get this timing right, it certainly was not alleged to be the date of release and isn't reasonable. I mean, and as you know, that date matters a lot for the statute of limitations, potentially. And so is it reasonable to read the complaint to say that she would have been receiving medical care, the day that she walks out of a facility and not just going through out processing?
Your Honor, I think it is, and again, for two reasons. One, this is again a complex chronic condition that needs to be treated every day. This isn't a broken arm where you cast it and that's barring some bizarre series of circumstances. That's it. And then I apologize. I said there were two things, and now I don't. I apologize. I'll stop there. I see that I'm cutting into my rebuttal time, so I'll reserve the rest of my time for rebuttal.
Very well.
Thank you.
Good morning. May it please the court. My name is James Grubel. I represent the Centurion defendants. I'm also speaking on behalf of all the defendants in this case. The defendants, Centurion and Wexford, provided medical services through a contract with the New Mexico Department of Corrections to inmates in correctional facilities, including Ms. Vasquez-Garcia, and Summit Food provided the food. This appeal presents a statute of limitations question that can be resolved on the face of the complaint. Ms. Vasquez-Garcia pleads dates that she was injured, specific dates starting in 2019. And the case authority in this circuit is specifically cited under Herrera and as well as Alexander and Hammer. The relevant date is the date the plaintiff knows that she was injured. The plaintiff does not need to understand the full consequences of that injury. It's the date of injury itself. So I'm going to intend to make 3 points today. First, under this court's decision in Herrera, the accrual date is based on the injury. Second, under Fernandez, if a complaint pleads sufficient facts to demonstrate that the acts took place outside of the limitations period, the district court should and really must dismiss the complaint. Second, the complaint is a 47-page, 138 detailed chronological description that affirmatively pleads knowledge of Ms. Vasquez-Garcia, that says that she was injured. And third, the completed violation doctrine does not apply in this case. As Herrera set forth, the continuous violation doctrine may apply in a case where there's an ongoing series of events that in and of themselves do not give rise to a cause of action, but put together cause injury. That's not what we have in this case. Now, I understand that plaintiff is trying to...
And let me interrupt for a minute on Herrera.
Yep.
I see Herrera as very different. In Herrera, all of the injury was caused when they shut off the water. And the subsequent events that he was trying to argue to extend the time was, I asked you to turn it back on. And the city said no. His injury did not change at all based on those subsequent requests because his full injury was they shut off his water. This is a different situation. We have a situation here where the argument is we have chronic conditions that aren't being treated or are being treated with in disregard for a period of time that is causing additional injury. Can you tell me why that's not an important distinction?
Your Honor, respectfully, I would assert that the the chronic conditions of the diabetes with Ms. Vasquez-Garcia pleads that she came into the prison with. The conditions that arose are sequelae, they are symptoms. She reports visual problems in June of 2020, again in September. She says she's seeing floaters. She goes to the medical providers and reports that. She then reports that she's got eye pain and she's got blurry vision again in 2020. And at that point, Wexford is the provider. She's then saying that she has kidney disease. But all of these are flowing from the initial, if we're saying the trigger is that she had untreated diabetes, these are all symptoms flowing from that. And if you look at Herrera and the other cases, the focus is on when is the date of injury. It's not the date of the ongoing symptoms of that injury.
Well, counsel, doesn't that cut against you? The fact that her intake into the facility showed that she had several conditions that are chronic: diabetes, thyroid disorder, blood pressure issues. And so when we're looking at, is there a serious medical condition that occurred? And typically we'll see cases where there's a hard and fast injury, it's just whether it's serious enough. But here, plaintiff is alleging that the baseline when she walked into the facility was she has all these conditions. And over time, there may be flare-ups and symptoms. And then it sort of details the reaction or the response or non-response of the medical professionals. So I guess, how does the fact that she checked in with these chronic conditions help your argument that there was something that happened during that time that would have given rise to a constitutional injury that accrued?
So, Your Honor, she did report pain. She had sensitivity in her eyes. She reported temporary blindness. At that point, I think a reasonable individual would know something's going on here. Whether she knew it was constitutional
Well, but that's the difference maybe also between knowledge of a symptom and an injury and, as counsel phrased it, the causation, the constitutional, the legal injury, that there's deliberate indifference towards that condition.
So, Your Honor, this case is not a traditional procedural posture. As noted in the New Mexico Department of Corrections motion to dismiss, on page 2, it notes that Ms. Vasquez-Garcia filed a state law claim on August 12th, 2021, 3 months after she was released from prison. I will also note, it's not on the record, but I think if the court were to inquire, I think you could take judicial notice that in that state law complaint, at allegations, the 8th cause of action and the 9th cause of action, Ms. Vasquez-Garcia alleges intentional infliction of emotional distress as well as conspiracy. So she's alleging, we know that in August of 2021, Ms. Vasquez-Garcia is alleging a mens rea, frankly, I think higher than deliberate indifference, to, that she was being punished by the individuals. Your Honor, I think if you look at the reasoning in Herrera and how it treated Shomo decided a continuous violation can be attributed to a ongoing chronic disease. Herrera didn't really adopt that. Herrera says, look, we look at each case by case, and we look at what's being alleged, and we really focus on, is there an instance that we can pin the statute of limitations to? Is there a date certain? And in this case, I would assert that the date certain is starting in July and September of 2019 when she reports to Centurion. I also note that plaintiff in the reply brief at footnote 7 says that the continuing violation doctrine would not apply to the providers who were not there at the time. That's not clarified. That certainly would be Centurion because they left as pleaded in the complaint in October of 2019. And Summit Foods, the only allegations against Summit Foods are that they didn't provide the prescribed medical diet, which was only prescribed in February and August of 2019. As to Wexford, the last allegation is that Ms. Vasquez-Garcia was diagnosed with stage 4 kidney disease on February 22nd, 2021. So that's,
But does it allege that she was notified of that diagnosis? As I read the brief, it seemed to be the argument was there's no allegations on the face of the complaint that she was aware of that.
Judge McHugh, you're correct. It does not allege that she knew. But that goes back to my point of, that's why I think the court, because otherwise, if the court's looking at sort of chronic diseases and when an inmate should know when or objectively when that person has a cause of action, it becomes problematic. If we're basing it on a release date, some inmates are in prison for long periods of time. Some never get out of prison. So the problem with plaintiff's argument is that we're allowing her essentially to get out of prison and talk to a lawyer to understand the complete nature of her injuries.
I think the problem here is that we're on a 12B6 and not a 56, because you could go and find someone at the prison who told her that she had stage 4 kidney disease on a specific date, and I think you'd have a very good argument that her claim was triggered that date. And in that way, the case reminds me, you cite Vasquez versus Davis, but in that case, they denied 12B6, and it was after a summary judgment was entered that it came to us. And the combination of this being a 12B6 and her statute of limitations being an affirmative defense, which she has no burden to establish in her complaint, makes, in my view, your position more difficult.
And Judge McHugh, to respond to the 12B6, yes, plaintiff did not have the burden to plead the facts regarding the defendant's affirmative defense, but she chose to do so. She did plead facts that she was injured in 2019.
But with it being 12B6, she's got to plead herself out of court, essentially, on the statute of limitations. And you say she pleaded these facts, but everything in the complaint we interpret in her favor. And so now we're having to do some gymnastics. It just seems like Rule 56 is a much smoother expressway than trying to negotiate every turn and some sharp turns for every complaint allegation and then plugging them in for what an objectively reasonable person would think with 20% of the important facts that we might want to know. That's my issue as well. Are you here too early?
Understood, Your Honor. I also would just point the court to paragraph 140 of the complaint, wherein, and this is in regards to the continuous violation, plaintiff asserts that she had 4 separate harms, and she's attributing those harms to prior allegations in the complaint at prior dates. And so I understand the court's concern, but again, we are here in a posture where plaintiff had additional information. This isn't a bare bones complaint. This is a very detailed complaint. And I think that's what's different. I mean, I understand it's different than Davis procedurally, or Vasquez versus Davis procedurally, but substantively, the number of allegations, if you assume what plaintiff is pleading is true, she knew she was injured.
But it says nothing about what she knew or what she was told.
As to some of the things, Judge Federico, I agree, in terms of what's in the medical records, but I don't think she can conceivably argue that she didn't know that she was having visual problems, because the only way that would get into the medical record is if Ms. Vasquez-Garcia
Sure,
told her.
that may be true, but again, as we've discussed, to have an accrual of an Eighth Amendment claim, it's kind of a high bar. And, it may be as my co-panelists have pointed out, that on summary judgment, the records will show that she was told all of these things and explain what they meant. But in the complaint, just beyond her saying vision loss and explaining some pain in her eyes in particular, You mentioned a moment ago, I thought that you said July of 2019, there was something that happened that would trigger accrual, but I guess I missed what it was, because again, I'm looking at the complaint and you're right, it's very detailed, but it says nothing about what she knew or was told.
It shows what she experienced, Judge.
Okay.
It doesn't say what she was told.
Okay, so what is it about, and again, I may have misheard, July of 2019?
It was June of 2019, I apologize.
At the blurred vision?
At blurred vision at 43, paragraph 46 is she saw the two air bubbles. Paragraphs 52 and 55, she's reporting that she had worsening vision and eye pain. She's also saying that she should have been given Avastin injections and she wasn't taken for Avastin injections. So at that time, she would have known that she wasn't getting the treatment that she asked for. Essentially, this is, I'm equating deliberate indifference with punitive damages. You can cite, what plaintiff is trying to do is separate and saying this constitutional claim is somehow separate from the negligence claims. You cannot have deliberate indifference to medical treatment without the underlying, at least medical negligence. And I think that separates it from a more generalized, more nebulous due process violation that someone doesn't know. She knew she was injured. The extent of the injury is not relevant. And she's pleaded that she knew she was injured as early as June 2019. Thank you for your time.
Any further questions? All right, thank you, counsel.
Thank you.
Your Honor, the questioning so far has revealed that you understand our theory of the case, so I'll just sort of try to be brief and just make a few points. First, I just want to reaffirm, it seems like you understand the injury alleged here is not a physical injury. The injury alleged here is a constitutional injury, and of course, one of the predicates for that is a physical injury, but the ultimate injury or the legally actionable injury is constitutional here. I also agree that the real issue here is that we're here in a 12b6 posture and not a Rule 56 posture. We're asking the court, I think, actually for fairly limited relief, which is just the opportunity to take some discovery, and then, defendants, I think, can essentially renew or may be able to renew many of these arguments again in a summary judgment posture. So I just wanted to emphasize, I think, how sort of limited the relief that we are actually asking for is. Judge McHugh, I just actually wanted to go back to your question. I believe earlier you asked me whether if a plaintiff, Ms. Vasquez-Garcia, or someone else in the deliberate indifference context reports what they understand to be a serious injury, and then the prison does, absolutely nothing about it. I just wanted to clarify that my answer to that question is, in that case, yes, their claim would have accrued under those circumstances. I think I sort of misunderstood or talked around your question, and I just wanted to come back to that briefly. Lastly, I just wanted to say that just to emphasize, I think the district court and defendants would like it to be the case that Twombly and Iqbal apply to affirmative defenses, and they simply don't. Under this court's case in Bisline versus Parker, the question is just whether there is a conceivable set of facts that is consistent with this complaint that places the filing of the complaint within the statute of limitations. I think the answer to that question is yes. If the court has no further questions, I'll cede the balance of my time. We ask the court to reverse.
Thank you, counsel.
Thank you.
Counsel are excused. The case is submitted. Thank you for your arguments. And at this point, we're going to take a 10-minute break before we pick up with Sousa versus Chipotle services.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Please be seated. I said 10 and took 15, sorry about that. Next case up is Sousa versus Chipotle Services, docket 25-20-08. Counsel, ready when you are.
Good morning. May it please the court. My name is Alexandra Jones. I represent the appellant Donald Sousa in this matter, and I do intend on reserving approximately 3 minutes for rebuttal. The only issue in this case is whether the district court erred in granting summary judgment in favor of Chipotle by finding that there was no material issue of fact with respect to pretext in this case. Mr. Sousa filed his claim based solely on the New Mexico Human Rights Act, claiming that he was discriminated on the basis of age when he was wrongfully terminated. There is no dispute that Mr. Sousa has met his prima facie burden for age discrimination under the New Mexico Human Rights Act. The only issue that the court ruled on, the district court ruled on, was that there was not evidence sufficient to establish pretext. In making that finding, the district court, in our view, improperly weighed the credibility of witnesses and made findings of fact that were improper at the summary judgment level. It is also my view that the district court ignored controlling Supreme Court precedent in New Mexico, which states that pretext is normally an issue for the jury, and that it is largely a credibility issue that comes down to issues of fact and circumstantial evidence that cannot be determined by a court and should not be determined by a court at the summary judgment stage. I also want to point out in Lincoln versus BNSF RICO, this court has consistently held that pretext does not have to be demonstrated in any specific way. It can be demonstrated through inconsistencies, implausibilities, and the like. That's exactly what this case is about. It's about all of the inconsistencies surrounding Mr. Sousa's termination. There are 3 specific points that I think the court got wrong in this case when it comes to pretext. There is inconsistencies involving the false written warnings that were issued contemporaneous to the final termination notice in this case.
Can we talk about those, please?
Yes.
The false warnings, as you described them, I guess I have a hard time understanding how those warnings could in any way be evidence of pretext. They're kind of nonsensical because they're dated the same day of termination, and I think Judge Browning described them as, quote, cooked up. But how could that give rise to pretext when, as I understand the argument it is, they were cooked up, to use the district court's words, to show that he was given an opportunity to sort of correct his conduct. But again, they're dated the same day as the termination. So can you help me understand how those could possibly be evidence of pretext?
Sure, absolutely, Your Honor. I think just what the court said is that it's supposed to create this this appearance that he was given an opportunity to improve his conduct, and he wasn't. And it goes to Mr. Hannon's state of mind. In Young v. Dillon, it talks about what we're talking about here is whether the decision maker actually believed what they were doing was correct and justified. And in this case, I think the fact that Mr. Hannon felt the need to create these 2, I'm calling them false warnings because they never were warnings in this case.
Yeah, but if his intent was to show that there was documentation to say, look, the company gave Mr. Sousa an opportunity to correct, and he didn't, so that's why we fired him. I mean, you would think if they were going to give false warnings, they would, make it a different date. How about 90 days prior, 180 days prior? Again, that's why I'm just having a hard time understanding how that could be pretext.
The documentation, if that was the only reason why they were created, then why not just give the final termination notice, which was a combination of these 2 final written warnings? I mean, their difference in substance is very confusing and very suspect. Why would he go back and create? I'm sorry, go ahead.
Mr. Hannon testified that the only reason he did it was because HR told him to. And I don't see any evidence that you have put forward that contradicts that statement. And I mean, in order for you to create a material issue of fact on that, wouldn't you have had to come forward with some evidence calling into question Mr. Hannon's testimony?
I don't think so, Your Honor. I think that that is a credibility determination about whether or not he's telling the truth on that. I think the fact that the person who he alleges told him that has no recollection of stating that, has no citations to any policies or reasons as to why Chipotle would issue 2 final warnings concurrent to a termination, calls into question the credibility of whether or not that's true, or whether that's just an after-effect excuse that he's come up with because he's realized that issuing the 2 final warnings at the same time is suspect. So again, I think that goes...
In Helgett versus City of Hayes, I mean, we rejected the idea that a plaintiff can withstand summary judgment merely by arguing that a jury could disbelieve a defendant's uncontested testimony. So yes, the jury does have the obligation to determine credibility, but if you're going to argue that somebody's statement is not true, you got to give them something to work with, don't you?
I think so, Your Honor, but again, focusing on the fact that there is no explanation, there's no reason provided as to why this would occur in this method, is that evidence that calls into question, why would you do that? That doesn't make any sense. It's, as Judge Browning said, looks like it's cooked up. Why are you creating these false records if there's no nefarious reason to do so? And so I think that we have provided evidence that calls into question whether or not that's true, combined with the fact that there is no written communications where HR is telling him to do that, despite the fact that there are multiple written communications surrounding the termination. Why is there no written communication directing him to do that? So I think all of that is more than us just saying they may not believe him. We don't have any legitimate business reason for Chipotle creating these 2 final written warnings. On top of that, just by the nature of how they were delivered concurrent to the final termination, they contain factual inaccuracies. And there's multiple inaccuracies as far as the exaggerations that Mr. Hannon gave regarding the conditions of the restaurant. Mr. Sousa unequivocally in his deposition states that they're inaccurate. And so I think Mr. Hannon's creation of these written warnings are attempting to exaggerate the situation, make it look worse than what really was, and I think he's doing that to justify a decision which he knows is not founded.
Does it matter that, as I understand it, Chipotle doesn't have a progressive discipline system?
I don't think it matters that they don't have a progressive discipline system to the extent that they were not required to follow one. What is concerning to me is that it seems to me that by creating these 2 written warnings, that shows a consciousness of wrongdoing on behalf of Mr. Hannon, like he feels like he should have given Mr. Sousa multiple opportunities to correct these issues, because I think he does that with other younger employees. And that comes into where I think he shows preferential treatment towards these younger employees and other field leaders in the same position who have documented pest issues, documented cleanliness issues, and he's not doing anything in those cases. No progressive discipline. He talks about verbal warnings that he gives them. But the treatment between Mr. Sousa and these employees who have documented issues is preferential.
Who created the forms, the warning and the termination?
Mr. Hannon.
And so I guess it's Ms. Barcelona just said, yes, go ahead,
She says she doesn't remember doing that,
according to Mr. Hannon.
according to Ms. Barcelona.
Oh, yes.
Ms.
Mr. Hannon says.
Mr. Hannon says HR told me to create the final warnings. And when I asked Ms. Barcelona in her testimony, why on earth would you ever do that? She said, the only reason I can think of, again, not giving me a direct explanation for this case, but the only reason I can think of is documentation purposes. Well, the final termination notice is documentation. And especially in a company that doesn't have a progressive discipline policy, why would you need to create the 2 final written warnings if it was really only for documentation purposes?
What about Judge Browning's findings on the comparative?
Yes, Your Honor. I think what he is expecting of plaintiff in this case is to find another case that fits this fact pattern exactly. And I don't think that that's appropriate under the pretext analysis. He relies on Garcia, which is factually distinct from this case. It was a reverse discrimination case where she hadn't even established her prima facie burden. And he says, oh, you were supposed to find infractions that were nearly identical to this. First of all, I don't think that's the standard under New Mexico law. Even if it is, we have established that. We have Orkin records of Mr. Sanchez in Phoenix, who has continuous pest sightings throughout his Orkin records, and it goes on to talk about the cleanliness issues. We have declarations from the facilities managers that was in those restaurants who talks about the cleanliness issues, how they would fail.
What seems to be missing, though, is evidence that Mr. Hannon was aware
Your Honor,
of the Orkin reports. And, and I think, would you agree that what's relevant here is what Mr. Hannon knew?
I agree it's relevant, and I would point the court to Josh Amy's declaration as well as his testimony. It's in appendix, starts on the first volume of the appendix 217. He talks extensively about Mr. Hannon knowing about these issues involving Mr. Sanchez. Mr. Hannon testifies that he knows that the store that Lady Chaparro supervised failed the EcoShore audits. This idea that an EcoShore audit, which is literally only there for the health and safety of the community and to make sure that the store is clean and safe, is not of comparable seriousness to these arbitrary internal audits, it's disingenuous. That is definitely just as serious as of an issue. And the fact that Ms. Chaparro receives no discipline, no write-ups, not even a verbal warning for a failed EcoShore audit when that store has never failed an EcoShore audit under Mr. Sousa's supervisory role, it's going too far. It's going into issues that we believe the jury should be able to determine. We're not comparing apples and oranges like the cases Judge Browning relied upon. We have the same supervisor. We have similar issues. We have food and safety issues. We are pointing to comparator evidence that we believe is sufficient to get to a jury. And with that,
The district court seemed to think it was important how long the uncleanliness, pest, lack of control had occurred.
So two issues with that. One, again, I think that the false warnings were created to make it appear that there was longer issues than existed. Second of all, that's contrary again to what Mr. Hannon states in an email on March 17th, which is also cited in our record, where he states the store is clean, the drains are clean. So that is a material issue of fact. On top of that, if you look at the Orkin records from Mr. Sanchez, those went on for months. It continuously talks about how the pest issues continued for months. It's the same amount of time that it went on. And with that, Your Honor, I'd like to reserve the rest of my time, if that's all right.
Good morning, Your Honors. May it please the court. My name is Betsy Bulat, and I'm proud to represent Appellant Chipotle Services, LLC, in this appeal. As Ms. Jones accurately recited for the court, this is a case where there is a single claim of age discrimination under the New Mexico Human Rights Act at issue. And the only question before the court today is whether there is evidence sufficient to submit to a jury that age was the but-for cause of Mr. Sousa's termination. Chipotle submits there was not, even under the de novo standard of review that applies here and viewing the facts in the light most favorable to Mr. Sousa. As I begin my argument, I invite the panel to ask any questions it may see fit. To start, the undisputed facts here show that Mr. Sousa failed to remediate a serious cockroach infestation spanning over 2 months. In the week prior to his termination, he failed to meet cleanliness standards at not 1 but 4 of his restaurants in a single week. Chipotle properly exercised its business judgment and found that it presented unacceptable risks to retain Mr. Sousa in the face of these cleanliness and food safe issues.
It wasn't abrupt about face, though, in that he had received recognition for clean stores or running a good ship at his stores, as well as getting a pay increase, right? Contemporaneously.
What the record shows, Your Honor, is that he met sales goals. He was not recognized at any point for cleanliness or food safe conditions, and that was for the 2021 year. So he received a merit increase based on his sales performance in 2021. There was nothing related to cleanliness or food safe standards associated with that. I respectfully disagree that it was an about face. Mr. Hannon met with Mr. Sousa on February 9th of 2022, and they had a lengthy conversation regarding his failure to keep the University of New Mexico Chipotle in good, clean order. This conversation continued on for the next 6 weeks. Mr. Sousa admits he was in constant contact with his supervisor, Mr. Hannon, about his restaurant, both UNM and others, about their cleanliness and food safe conditions.
All right, well, here's what I'm talking about, and you can tell me that I'm wrong, and I'll double check. But my information is in 21, in a routine weekly video message to the company, Chipotle recognized Sousa as a top-performing field leader in the company. The recognition was based on Sousa stores receiving an AB rating, which refers to Chipotle's store rating system that considers cleanliness.
An AB rating, Your Honor, considers multiple factors. I believe it's upwards of 20 factors.
Right. Is cleanliness one of them?
I'm not sure, Your Honor.
All right.
What I do know is that the record indicates that Mr. Hannon recognized performance based on sales performance. And he did hit that for 2021. There's no dispute about that. There's no dispute that his restaurants weren't making money. There is evidence that he wasn't meeting food safe and cleanliness conditions in 2022, in about the 2-month period that we're talking about here. So to survive—
Why aren't Mr. Chaparro and Mr. Sanchez helpful comparators here?
Thank you for that question, Your Honor. I'll start with Ms. Chaparro. The only evidence in the record that she engaged in anything comparable or similar to Mr. Sousa's misconduct is one failed EcoSure audit in July of 2022. And that was at the same University of New Mexico restaurant that experienced the cockroach infestation under Mr. Sousa. That was a single third-party food safety audit that she failed. There was no evidence of any of her culpability in that. There was no evidence that the restaurants were unclean as part of that audit.
I'm sorry, counsel, what do you mean there's no evidence of her culpability? Isn't that her responsibility?
So she'd had the restaurant for 1 or 2 months. There was never a finding made that the issues there were related to her. She had only had the restaurant for a number of, 4 to 6 weeks.
But who else would they be related to?
To Mr. Sousa, who turned the restaurant over to her in the prior 2 months.
Well, but if Mr. Sousa was terminated because on February 8th, there was an infestation call, and then he gets fired on March 28th, that's not even 2 months, then why wouldn't Ms. Chaparro be held to account if she gets the restaurant turned over to her from Mr. Sousa, and then 2 months later, there's still cleanliness issues?
It's a fair question, Your Honor, but what I will say is the record has no evidence showing any of Ms. Chaparro's culpability other than the fact that she failed this audit. So it could be a fair assumption or an inference that Your Honor is drawing from the record, but the record itself doesn't associate this failed audit with anything that she did wrong.
Well, then why shouldn't we read the record to say there's no evidence that Mr. Sousa was culpable?
I would respectfully disagree there is, Your Honor. So in the first instance, on February 7th, Mr. Sousa was notified of the cockroach infestation. He didn't let his supervisor know about that until he never did. The next day, Mr. Hannon was copied on an email after it had been escalated. So that type of issue should have been immediately escalated. They had a meeting on February 9th to talk about the issue, and Mr. Hannon told Mr. Sousa, you need to stay on this, remediate this, and fix it. And they stayed in constant communication about that, and he didn't. In fact, on March 17th, Mr. Hannon learned not only was the cockroach infestation persisting, that Mr. Sousa had allowed the Orkin treatments, the extermination treatments, to drop off. And not only that, he knew about it. He knew they had dropped off and didn't ask them to come back. And on that March 17th—
I thought the evidence was that as soon as he found out that they weren't coming as frequently, he directed them to start coming every day or every other day as they were before.
He did at some point, Your Honor, but not immediately. As of March 17th, he had not done that. Following that March 17th meeting, he did do that. And
When did he learn that that they weren't coming as frequently?
I don't know if the exact date is in the record, but there is evidence that it was weeks. It was a matter of weeks. And at that March 17th meeting preceding the termination, he was there not only with Mr. Hannon, who saw upwards of 6 cockroaches, but another field leader that worked for Mr. Hannon named Elsa Armendariz, and a cockroach fell on her from the ceiling. This is something that if he was actually in his restaurants, it's something that he would have noticed.
Well, counsel, I guess I don't have a problem with the idea that Mr. Sousa, as the field manager, is responsible for the cleanliness of the store, and it seems to be the evidence was there was an infestation of cockroaches. And that's a problem for him because that's his responsibility. What I'm having trouble, though, is on the comparator evidence. I guess I understood the Ms. Chaparro distinguishment to be something other and different than, well, there's no evidence of her culpability. I mean, it's her store. She's the field manager, so she's in charge of making sure it's clean. So is there another way to distinguish her as a comparator to Mr. Sousa other than saying, well, it's his responsibility, we're going to hold him to it, but not her because we don't have evidence of culpability?
Absolutely, Your Honor. It's the frequency of the misconduct and the severity of the misconduct. And I think a helpful case to look at is the Kendrick versus Penske transportation case from the 10th Circuit. And that's a case where the plaintiff there was terminated after getting into a physical altercation with another employee. He bumped chests with him, and he was fired for it. There was a comparator employee there who took a crowbar and threatened another employee, but didn't actually make physical contact with the other employee. And the 10th Circuit supported the employer's decision in terminating the plaintiff there because they allowed them to find that a physical touching was more severe than simply threatening someone, where a touching didn't actually occur. Similar conduct, but not the same. So here, we have a failed audit. Yes, Mr. Sousa didn't meet cleanliness standards in 4 audits, and he had a long cockroach infestation. So kind of similar, but less severe, and certainly different under the Penske case.
Do you think the standard, go ahead, Judge McHugh.
I was just going to switch to Mr. Sanchez, but if you want to still talk about Ms. Chaparro, you should go first.
No, please proceed.
It seems like we have more evidence about Mr. Sanchez's store than we do about Ms. Chaparro's. And it does seem that there was a bad roach infestation at store 861, and that there was a rodent issue in store 1684, and store 898 had persistent cleanliness problems, apparently due to using too much water to wash the floors. And cockroaches were seen a year after Sousa's termination, and this store originally was Mr. Sousa's. Cockroaches were seen throughout store 3642. That sounds, how is that not a good comparator?
Thank you, Your
What
Honors.
happened to Mr. Sousa?
I'll attempt to go store by store. So store 861 was Tiffany Rodriguez's store, not Mr. Sanchez's. She took it over from him in September of 2020, and 2 months later, she was terminated for a cockroach infestation that she failed to remediate. So if anything, Your Honor, that shows consistent treatment among managers who engaged in the same or similar misconduct. To go on to restaurant 1684, there wasn't any cockroach sighting at this restaurant. This was a rodent sighting, and it was a rat that came in through a hole in the ceiling. And this is important to look at why pest sightings or rodent sightings or cleanliness issues at all occurred in a restaurant. Because to show pretext, it can't just be showing similar misconduct. It must show that there's no other non-discriminatory explanation for why the similar misconduct was treated differently. The rodent sighting at 1684 was different because there was a structural issue. There was a hole in the ceiling. there was no evidence of Mr. Sanchez not being proactive or mishandling the siding, and it was quickly fixed. With respect to store 898, there were multiple cockroach sightings there, you're correct, but these were also structurally related. There was a grouting issue under the door where the grout kept deteriorating in that restaurant. Mr. Sanchez promptly responded and diligently attempted to resolve those sightings. All of this testimony, Your Honor, is at page 309 to 310 of the appellate record. With respect to to store 1684, that's at 306 to 307 and 315 of the appellate record. With respect to store 3642, this is not a restaurant that has ever been raised in this by plaintiff appellant in this appeal that I've seen. So I'm not prepared to address that. But what I do know is that there's no evidence in the record that Mr. Hannon knew anything about any issue at that particular restaurant.
Counsel, when we're looking at comparator evidence, there's some disagreement about the standard that applies under New Mexico law, whether it's nearly identical or comparable seriousness. Do you think it makes a difference to our analysis and the outcome, which standard?
I don't, Your Honor, because the district court analyzed the comparator evidence under both standards. And if you look at pages 89 and 87 of the order, you can see the judge's analysis with respect to Ms. Chaparro under the comparable seriousness standard and Mr. Sanchez under that standard. And just to direct Your Honors to the appellate record, going back to the comparators, everything that we have, all of the evidence we have on the misconduct of Mr. Sanchez, there's no evidence that Mr. Hannon was aware of it. The only thing we have in the record is that Mr. Hannon thought there might have been an issue. There's no other evidence that all of the specific issues at the restaurants that we detailed in our reply brief before the district court was something that Mr. Hannon was aware of or addressed. In my final minute, I did want to address the appellant's argument that the district court did not consider the evidence of pretext as a whole. First of all, there's no indication that the district judge didn't consider the evidence the whole. It was a 98-page order that exhaustively detailed the appellant's evidence of pretext. So there are no magic words that a district judge has to use to say, I considered the evidence as a whole. That would be a hyper-technical and absurd requirement that the 10th Circuit doesn't apply and doesn't require. And plaintiff's counsel or appellant's counsel appears to contend that even if none of her arguments amount to pretext, the sheer number of arguments as to pretext should be sufficient to get to trial. But mathematical precepts show that 0 plus 0 plus 0 doesn't equal 3, it still equals 0. So here, the fact that Mr. Sousa has numerous arguments about pretext doesn't, by their mere number, make them sufficient to survive summary judgment. This exact argument was considered by the 10th Circuit and rejected in the Riggs versus Airtran Airways case, 497 F. 3rd, 1108, 10th Circuit 2007. So here we would submit that this panel affirm the district court's grant of summary judgment. I thank you for your time and consideration.
Thank you, counsel.
Thank you.
Thank you, Your Honor. To follow up on what was just said about Ms. Chaparro can't be held responsible, and there's no indication that it was her responsibility for the failed EcoShirt audit, well, then that begs the question as to why Tiffany Rodriguez was fired for a store that she just inherited for Edwin Sanchez, who was never disciplined for any of his cleanliness issues at that store, and whose name was actually still on the store when the only other person in her 50s under Pat Hannon's control was fired for similar issues. Opposing counsel seems to think that that shows consistency. I think it shows a pattern of discrimination, that Mr. Hannon was intent on getting the two only individuals who were in their 50s, who were close to vesting on their 401k, who had a bigger financial interest in this corporation, out of his team and making room for the two younger employees that he wanted on his team, which were both in their 20s and 30s. So no.
Does a pattern have to include the employees who are 40 or older as well?
I don't think so, Your Honor, not when it comes to pretext. I think that again, the overall cumulative argument is not 0 + 0 + 0 = 3. It's the fact that we've got to take a step back and look at what happened altogether and look at the fact that Mr. Hannon took the only 2 individuals who were over 50, replaced them with younger employees. He used an extremely common issue as indicated by all of the Orkin records in Mr. Sanchez's case, as indicated by the failed EcoSure audits. Cleanliness and pest issues are common in the restaurant industry. He capitalized on those only with respect to these 2 employees, and with respect to Mr. Sousa, did not give him any opportunity to improve, and his treatment of Mr. Sousa was completely disparate to the other younger employees on his team. And so for that reason, I think we have established it, at a minimum, a material issue of fact with respect to pretext, and would ask the court to reverse the district court's ruling.
Thank you, counsel. Thank you for your arguments. The case is submitted and counsel are excused. All right, I think everyone is collected. The next case for oral argument is Sanchez versus Torrez, docket 25-2009. Counsel.
Good morning, Your Honors, and may it please the court, Chris Kieser for Appellants. I'd like to try to reserve 2 minutes for rebuttal. My clients are New Mexico landowners who hold title to the beds of non-navigable streams running through their land. For decades, they had the right to exclude the public from walking and wading on those stream beds. Until 2022, all 3 branches of New Mexico government recognized these rights, and my client, Mr. Briones, even had signs from the Game Commission and the Department of Game and Fish issued to that effect only a few years ago. The defendants here, the commissioners, the director of the Department of Game and Fish, and the Attorney General, all flipped their position only after the New Mexico Supreme Court, for the first time in state history, declared that the state constitution's public water clause guarantees public access to walk and wade on these privately owned stream beds. After that decision, the state officials began cracking down on property owners who still wish to exercise their right to exclude. The Attorney General has already sued 2 of my clients and threatens more action, while the Commission and the Department have warned stream bed owners not to display even the signs that the agencies themselves issued only a few short years ago.
Is it cracking down or just enforcing the law?
Your Honor, that's precisely what they're doing. They're enforcing state law, and that's exactly why this is a classic Ex parte Young case. The streamboat owners allege that New Mexico's taken their right to exclude by essentially defining it out of existence. Because New Mexico can't be sued for inverse condemnation in federal court, the owners sued the officials who enforce state law through Ex parte Young. They've already enforced the law. They threaten to enforce more in the future. This is exactly the function of Ex parte Young. When state officials are enforcing state law in such a way that it violates a citizen's federal constitutional rights, the citizen may obtain prospective injunctive relief to stop further violations, and that's all we seek in this case. I think
What is the federal constitutional right that we could announce in view of the New Mexico Supreme Court's ruling, on which I think its word is final?
The New Mexico Supreme Court's ruling, Your Honor, is a final ruling as a matter of state law. And we don't contest that Adobe Whitewater is a pronouncement of state law. This court, of course, has no power to overrule Adobe Whitewater, but this is just like any Ex parte Young case. When a state legislature passes a law and someone challenges it under Ex parte Young, the enforcement of that law, and the state and the federal court finds that those rights were violated, it doesn't go back and then cross out the state law or overrule it. It just says you can't enforce that law against these parties.
Well, it sounds like you're saying there's a higher right than the right that New Mexico has recognized a higher federal right. What is that right?
It's the
And
right.
what's its source, more importantly?
The right to exclude is the right, as the Supreme Court has most recently recognized in Cedar Point Nursery. The right to exclude is one of the most fundamental property rights. And in here, essentially, what the state officials are doing is enforcing a public easement on these private stream beds. It's exactly what happened in Cedar Point, where the Supreme Court held that it was a taking and of the right to exclude to require the growers in that case to allow union organizers onto their property 120 days per year. It's exactly the same thing.
You describe the right as the ownership interest, but the right is not to have it taken without just compensation, right? That's the constitutional issue.
That's correct. So it's the right to exclude, which cannot be taken without just compensation. And just as in Cedar Point, where
it's not the right to exclude, it's the right. It's that if you have a right, it can't be taken without compensation, whatever your right is.
correct, Your Honor. Just as in Cedar Point, when the growers
So
there.
you've got a decision from the state Supreme Court saying that you never had such a right. And that means nothing was taken. So there would be no need for just compensation. Are you asking us to overrule the state of New Mexico Supreme Court decision on what the New Mexico Constitution means?
Of course not, Your Honor. You have no power to do that. What we're asking for is to understand that a state cannot simply define a right that has existed for years out of existence, whether it's through judicial proclamation, through a legislation, or through executive action like in Cedar Point. And so just the...
But you're ignoring what I'm saying. They didn't do that. What they said was it never existed the way you're defining it, and that we never even said that in our prior decision. And so in order for us to, I do think you have standing. So, but in order for you to have a cognizable claim, I don't know what we can do if the state Supreme Court has held that the right you claim has been taken without just compensation, you never had, ever, in the state of New Mexico.
Your Honor, this is why the Supreme Court in Cedar Point and Tyler versus Henneman County has emphasized that the states are not the final expositor of property rights. And it's asked lower courts to look to things like the tradition of the right being recognized in the past. And here we have exactly that. Our complaint alleges decades of proclamations from the Department of Game and Fish and the Commission, the Game Commission, recognizing the right to exclude. Then there's a 2015 statute that recognizes the right to exclude, and a 2018 administrative rule.
Counsel, can I pick up that thread with Tyler, in particular that case? The Supreme Court said, I think you correctly noted, that state law is not the final word on property rights, and one of the things you look to is historical practice. Even though here Adobe Whitewater says, well, they never had the right, we're just now making explicit what the Constitution's always said, but that right never existed. Is it your argument, though, that the historical practice within the state that always did recognize a right the Supreme Court said never existed is enough under Tyler to conclude here that, when we look beyond just Adobe Whitewater, there may be other sources that give rise to a takings claim?
Yes, and Your Honor, and one of those sources is the Supreme Court, the New Mexico Supreme Court's decision in Red River Valley, which I recognize that the Adobe Whitewater Court just viewed themselves as applying Red River Valley. But if you look at the Red River Valley opinion, and it's the reason why the department and the commission had taken their position on the right to exclude for all those years, because Red River Valley is a decision about public water, not about the land beneath the water. And in fact, when it denied the rehearing motion, it was careful to distinguish between those things. It said that it's not a trespass to fish from a boat above the owner of the stream when the stream beds are privately owned. But it would be a trespass to walk and wade. Now, they didn't explicitly say it would be a trespass to walk and wade, but that's the implication there, and that's exactly what the executive agencies picked up on in issuing their proclamations, and then that was made explicit in 2015 via legislation and in 2018 via the rule that allowed the certification and the signage to be issued. So by 2022, it was clear that the political branches understood in New Mexico that there was a right to exclude. And Adobe Whitewater, of course, held that it didn't commit that it didn't change the law in such a manner to commit a taking, but the state Supreme Court is not the final word on that. Federal courts are the final word on whether a taking has occurred. And so here, my clients were not parties to Adobe Whitewater. After 2022, they have experienced these enforcement actions, and that is what gives us standing. And then it's the enforcement actions themselves. I think a lot of the argument sort of misunderstands what Young actually does. The source of the state law doesn't actually matter. It could be an executive proclamation, a rule like in Cedar Point, it could be a statute like in Young itself, and it could be the state constitution or a judicial interpretation of the Constitution. In any event, it's the enforcement that is what matters. And here, my clients only seek to restrain the enforcement of what is now considered to be New Mexico law. And of course, New Mexico, if they want to have these public rights, they can have them. And as Judge McHugh pointed out, they could pay just compensation for these rights, just as Justice Breyer pointed out in his dissent in Cedar Point. That injunction could be dissolved if the state decides it wants to pay for the rights that it took. But that hasn't happened, and so that is why under NIC we're entitled to a federal forum, and the only remedy we can get in a federal forum is prospective injunctive relief, and that's why we've sought that in this case. So I want to move on to the sovereign immunity question. I think that it's kind of intertwined with the standing in Ex parte Young, but I think the district court on sovereign immunity, it assumed that the state officials would not be able to comply with an injunction, but that's just wrong under Ex parte Young. The state officials would have to comply if there is an injunction issued, and therefore there's no way that this case could result in draining the state treasury. It's just a classic Ex parte Young case. And nor do we have to go.
Well, I guess the state could choose, right? The state could choose to continue to enforce it and compensate.
That's correct.
But they wouldn't have to.
That's correct.
Because
I'm sorry, Judge.
I'm sorry, but if the state enforcers would have no right to enforce a law that's been struck down as unconstitutional by the federal court.
That's correct.
Under the federal constitution. Okay.
That's correct, Your Honor. So there's no way in which the relief that we seek is not prospective, and that's why it is properly sought under Ex parte Young. And the argument the district court and my friend on the other side make about having to go to state court first seems to be, they cite Williamson County, which is a case that's been overruled. There are cases that's like this court's case in Williams that say that if retrospective relief is being sought and the state courts are open to hearing that case, then you do have to go to state court. But that is not a case about prospective relief under Ex parte Young. That's just a garden variety sovereign immunity case. And so here, we don't have to go to state court. We have a right to a federal forum under NIC.
Well, I was a little confused by those cases because it's a little hard to tell in some of them whether they're saying you have a requirement to exhaust essentially in the state court, or if it's just a decision saying that equitable relief is not available if you have an adequate remedy at law. And I think it matters here because one is jurisdictional and one is not.
Yes, Your Honor, you don't have to.
Do you understand my confusion?
You don't have to exhaust because NIC overruled Williamson County. There's no more state litigation requirement. As far as the other, wait, I'm sorry, what was the second part of your question? I just wanted to make sure.
Well, if you're looking for equitable relief, typically you're not entitled to equitable relief if you have an adequate remedy at law.
Sure. Yes, so the reason we're entitled to equitable relief is the same reason that the growers in Cedar Point were entitled to an injunction and ultimately did get one, because they were suing state officials who can't be sued for inverse condemnation. And that's why they're entitled to equitable relief. I'd like to try to reserve.
Counsel, before you sit down, you're invoking Ex parte Young, and the primary justification I hear for it is your prayer for relief in which you are asking for permanent injunctions. But what about the declaratory relief you seek, where you want the district court to declare that defendants essentially have committed a per se taking of plaintiff's right to exclude? If that is declared, is there any other option they have at that point other than to provide just compensation?
Yes, Your Honor. They don't have to. They can just continue to not enforce the law against my clients, and then it wouldn't be a taking, because we don't have a right to any retrospective relief. We only have a right to prospective relief, and that's all we sought.
So you don't think it makes any difference whether it's a declaration or an injunction?
I think the declaratory relief goes hand in hand with the injunction, but I don't think it makes a difference as far as that goes, no. I'd like to try to reserve my remaining 45 seconds. Thank you.
Good morning, Your Honors. May it please the court. I'm James Grayson, represent the appellees in this case. The New Mexico Supreme Court rejected the same takings argument that is being made by the appellants in this case because, quote, any title by interveners was already subject to the public's easement in public waters. Today, we merely clarify the scope of that easement by making explicit what was already implicit in Red River. The fundamental flaw in the plaintiff's claim in this case is that there is no underlying federal right that is being asserted. In New Mexico, the public owns the water, and there is not, and there has never been, a right to exclude the public from enjoying recreation and fishing on those waters.
So in Adobe is what the court's talking about, incidental use of, say, the banks or touching the bottom. You don't take the position that people can just walk over private property to get to these waters, do you?
No, Your Honor. And in fact, the New Mexico Supreme Court was very clear that that cannot be done. The New Mexico Supreme Court was clear about that in Red River as well. That was the trespassing that the New Mexico Supreme Court mentioned in 1945. It was crossing private property to get to the water. And in Red River, the court was talking about a lake, and the lake could be accessed by other means. That people didn't have to go through the plaintiff's property in that case in order to get to, in order to access the lake. There was a separate dock. And that also explains why the court didn't address the beds and the banks. That was not an issue in that case because it was a lake and it was accessed by boats, and the fishing was done by boat. What the New Mexico Supreme Court determined is essentially it's not a very large leap to say that an easement must provide access in order to use the land for the purpose of the easement. And here the easement, the purpose of the easement is recreation and fishing. And so the New Mexico Supreme Court went no further than to say the public has to have access to the water in order to have recreation and fishing.
Meaning you can stand waist deep with your waders and cast your line.
That's correct, Your Honor. And the court said that has to be only use as reasonably necessary, and was very careful to implement a balance between private property rights and trespass and the public's right to water.
Counsel, you
What do we do with the fact that, I'm sorry.
No, go ahead, Judge McHugh.
What do we do with the fact that it seems like whatever Adobe says Red River meant, it looks like that agencies in the state may have interpreted it more broadly than the Supreme Court now says it intended. What do we do with the fact of there were regulations in place and there were signs that were approved and all of that in terms of the property owner's interest in the land?
Yes, Your Honor, I think it's a very important question, and I think the Supreme Court, New Mexico Supreme Court did address that in Adobe Whitewater, both in saying that the administrative regulations were ultra vires and unconstitutional under the New Mexico Constitution, and in saying that they're holding in Red River. And the court, there was an extensive analysis of the holding in Red River and the discussion of dissents in the Colorado case that was relied upon by the New Mexico Supreme Court in 1945, in order to reach the conclusion that it was implicit in that holding in Red River that the public could access the banks and the beds to the extent reasonably necessary. So that was always the law in New Mexico. It was misinterpreted by the administrative agency in a manner that was ultra vires, because the New Mexico Supreme Court also said that the statute that was passed in 2015 was interpreted in a constitutional manner to mean someone could not cross land and then wade and walk in the water. They had to walk or wade from a public access point. And that is the trespassory right that landowners retain.
Counsel, you began your presentation by saying that they're invoking, the right that they never had. But why isn't that a merits question?
Your Honor, I think it's both a merits question and a standing question, because they have to plausibly allege a right in order to establish standing, and they haven't done so in this case. So whether the court decides that as a matter of standing or whether it decides that as a matter of 12b-6, it's the same.
Well, but the argument, as I understand it, is that even though Adobe Whitewater may say that they have no right to exclude this public easement access, but we don't just look to state law under Tyler versus Hennepin County. And in fact, historical practice, federal court precedents also inform this decision as well. So I read your response to obviously and rightfully rely heavily upon Adobe Whitewater. But what about other sources of law that a district court may look at to give rise to a property right that could be subject to a takings claim?
And that's the problem, Your Honor, with the assertion here that state law is not the only source of a property right under the takings clause, is because they've identified no other source. They haven't identified riparian water rights. They haven't identified federal property rights. Those were both dealt with in Red River and rejected. There is only a state water right. And what they're claiming is that the New Mexico Supreme Court misinterpreted that state water right. And so this is the problem that the Seventh Circuit confronted in the Pavlok case as well, because the Indiana Supreme Court in that case had said, since 1816, the land has been the state's up to the high water mark of Lake Michigan. And it was a retroactive assessment of state law. And the Seventh Circuit said there's no way for us to grant relief without saying that the state Supreme Court was wrong on a matter of state law.
Right. In that case, the Seventh Circuit decided on standing, didn't they?
They did, Your Honor. They did.
But it's very different, because in that case, the only injury they argued was the loss of these inches of property. Here, the injury that's asserted is the fear of prosecution. And it seems to me they clearly have stated an injury for standing purposes. You may have a good merits question, so I guess I'm following on Judge Federico's argument, but with regard to injury for purposes of standing, isn't it true that if you have a realistic risk of being prosecuted for violating the law, that you've got standing?
Your Honor, the realistic prospect of prosecution or enforcement relates to the right. So the right underlies that. There has to be a plausible allegation of a right. And that's why the Seventh Circuit said non-enforcement will not change the content of the underlying law itself. So non-enforcement...
But in the Seventh Circuit case, there was no risk of enforcement that was argued as the injury for purposes of standing. The only injury they argued for purposes of standing was the loss of that land, right?
And Your Honor,
here they have made a separate injury. I guess I think they have standing, and I think it's a merits question.
And Your Honor, like I said a few minutes ago, I think the court could decide this under 12b-6 because there are no facts alleged that would support a state source of the property right in this case. They've relied on administrative regulations, but the Game Commission and the Department of Game and Fish do not decide property rights. They have no authority to declare that these individuals own or have the right to exclude property owners from their property. So it's not a reasonable expectation on the property owner's part. This was not a matter that had been judicially decided until 2022, and at that point, the New Mexico Supreme Court decided as a matter of state law that that had always been the law in the state, and there's simply no grounds in the complaint to go behind that assessment, whether it's through history, whether it's through traditional property law, and in fact, the New Mexico Supreme Court's holding is actually a proper application of a principle articulated in Cedar Point itself. In Cedar Point, Chief Justice Roberts said, "Many government-authorized physical invasions will not amount to takings because they are consistent with long-standing background restrictions on property rights. The government does not take a property interest when it merely asserts a pre-existing limitation upon a landowner's right." And that's exactly what happened here. Now, this is not the ipse dixit that is alleged from Tyler or from Webb's Famous Pharmacies. In both of those cases, there was private property recognized by the state, and there was the state then changing the law to say that the property would be treated as public for a particular reason. In Webb's Famous Pharmacies, it was because the money was held by the court until it was dispersed, and it was considered public money during that time. In Tyler, it was because a law was passed saying that arrears in property tax could allow the state to take the property even in excess of those taxes. In both of those situations, there was an existing property right that was changed. And in both of those cases, the Supreme Court said there was an appropriation by the state. Here, there was no appropriation because there was never a right that existed. And an appropriation is what is necessary to allege a takings.
Counsel, can I pivot to the sovereign immunity part of this case? You, in your response brief, as I recall, relied upon Williams, a case that talked about sovereign immunity's application in a takings case. But does that case speak at all to the exceptions to sovereign immunity, like the one invoked here?
Your Honor, reading Williams, it does appear to be a damages case. It's unclear how Williams applies to an ex parte Young situation. There was a 28J letter that was submitted under with an unpublished opinion from this court, Teva Pharmaceuticals, that seems to indicate that Williams does not apply to ex parte Young. I think that's a complicated question, and I think that's not something that's been substantially developed in the law at this point, based on the change in the law affected by the Supreme Court. And so I think there are easier paths in this case toward affirmance. And essentially that's what the Seventh Circuit said in Pavlok as well, is that there are complicated questions with sovereign immunity, especially with Coeur d'Alene. I know the appellants here have suggested that Coeur d'Alene is only about cases with two sovereigns. Reading Coeur d'Alene, it never says that. The only place it talks about two sovereigns is to say that the court had rejected the notion that the 11th Amendment did not apply to suits between two sovereigns. So it's not a two.
Coeur d'Alene is quite different. It essentially would divest the state of any ownership over the land at all and any right to regulate it, right?
Your Honor, that's correct. It is an ownership case. In this case, however, what we're talking about is public water. And there is a sovereign interest by the state of New Mexico in public water. It is held in public trust. And that is something that was discussed in Coeur d'Alene. And in fact, Coeur d'Alene was about one lake in Idaho. This case is about all of the streams in New Mexico. All of the streams in New Mexico are public, and it is the state's sovereign interest to act in the public trust to protect the public's access to that water for recreation and for fishing. So this is, Your Honor, one of those special circumstances that does fit that Coeur d'Alene mold. But like I said, as in Pavlok, the court has easier paths, and standing is one of those paths.
You mentioned the easier path. From the state's perspective, what's the easiest path this court could take to affirmance?
Your Honor, I think it's actually any component of standing. I think all components of standing require the fundamental prerequisite of a plausible assertion of a right. And if that doesn't exist, there's no injury in fact, there's no causation, and there's no redressability for the reasons we discussed in the brief. I did want to say on the two sovereign point for Coeur d'Alene that the appellants relied on Stewart, and I wanted to clarify how the Supreme Court characterized Coeur d'Alene and Stewart. Because what the appellants say is that the quiet title language from Coeur d'Alene is dicta. But in Stewart, the court said that we determined that the suit was the functional equivalent of a quiet title suit against Idaho, and it would extinguish the state's control over a vast reach of lands and waters long deemed by the state to be an integral part of its territory. Your Honors, the streams in New Mexico are an integral part of the state's sovereignty, and the state asks this court to affirm.
Thank you, counsel.
Thank you, Your Honors. I only have 42 seconds, so I just want to make one quick point about Red River Valley and just in general about Tyler and sources of state law. There are many different sources of state law, and Red River Valley was merely one of them. But Red River Valley was clear that it interpreted the public water clause to allow fishing in the public water, which the public water has always been public, but it also clarified that no person has the right to approach public water through private property or to fish in public water while on private property, which would be the stream beds here, without consent of the owner. And that's exactly where the executive and legislative got their positions from. It didn't come out of nowhere. Thank you, Your Honors. I ask the court to reverse.
All right, thank you, counsel, for your helpful and excellent arguments. The court, you are excused and the case submitted, and the court will stand adjourned till further call.